Hello, everyone. First of all, I would like to extend a very warm welcome to each and every individual present here for the 2 days multidisciplinary conference, international conference, entitled as Emerging Issues and Challenges of Human Rights and Commercial Law, as well as Women Empowerment in Contemporary Global Society. This conference is organized by Shri Shivaji Shikshan Sanstha's Dr. Punjab Rao Deshmukh College of Law, Amravati, India, in collaboration with Sentinel Solicitors, United Kingdom. To begin with, I would like to wish you all a very good afternoon, evening, or morning to wherever you may be tuning in from. My name is Aditi Thakre, and I will be your host, a sincere host for today on behalf of Dr. Punjab Rao Deshmukh College of Law, Amravati, India, and Sentinel Solicitors, United Kingdom. Today, we are present here for the topic to discuss on the topic of women empowerment. As yesterday, we have discussed on the emerging issues and challenges on the commercial law. We had various respected dignitaries with us, and today we have a beautiful bunch of women dignitaries present here with us. A woman is a complete circle, it is said. She has the power to create, nurture, and transform. And here, today with us, we have the first Indian resource person for our conference, Dr. Shashikala Gurpur ma'am. She's our first dignitary in the conference. She is presently the director of Symbiosis Law School, Pune. Gurpur ma'am is an accomplished academician, a passionate researcher, and a Fulbright scholar. She holds a PhD in international law from the University of Mysore. She has received Karnataka State Government Award, and she is also the gold medalist in LLM. She has presented more than 339 invited lectures, workshops, and seminars across the globe. Ladies and gentlemen, I would like to seek your attention not only on Gurpur ma'am's achievements, but also on her work, as she is not only the conveyor of her ideas or thoughts, but she is also the action taker, for which Gurpur ma'am has been recently conferred with the prestigious annual Kittur Rani Chennamma Award by the government of Karnataka, India in 2018 for her work towards the empowerment of women. Unfortunately, Gurpur ma'am was unable to join here with us in the meeting, but she has honored us by sending a video to enlighten us on this topic of women empowerment. I would now request the technical team to play the video of Gurpur ma'am.
Good afternoon, the respected co-panelists, the leadership and the principal of P.D.C.L College, Amravati. It is my pleasure to be addressing the participants and all of you here on the theme of emerging issues and challenges on human rights, commercial law, and women empowerment. There couldn't be a better occasion than the eve of International Women's Day. I would have loved to listen to the co-panelists and be in a live session, but due to the sudden appearance of a VIP visit, I request you all and seek your apology for not being able to do so. The loss is all mine and the liability also is all mine. Otherwise, I would have been enriched very much by listening to esteemed panelists and the learned wisdom from them. Now, my whole theme is going to be focusing on some stories that I want to share with you. When we are talking about women empowerment in the line of human rights and emerging global challenges, what comes to our mind is, how do we decode women empowerment? There's a lot of scholarly literature in this area. However, if you go through the literature, there are two concepts which come competing with each other. One is empowerment, which is about giving power to women. As it is said, women hold half the sky, means they consist of 50% of the population on this earth. They are half the humanity. That means inherently they have the power. This power either hasn't manifested or it has been prevented or deprived. That is why the word empowerment, which means realizing that power or enabling that power, which if you decode boils down to the power that is exercised, the controls that they have, and the participation opportunities that they have, and the choices that each individual woman makes. Now, if you look at the power that they have, what is power? For a lawyer like me, power is the ability to influence. Power is the ability to alter one's own status or other status. As far as women are concerned, them altering other status is more in the line of a kind of negotiated position. It's a kind of co-participatory position. As far as altering their position, it seems to be something where they don't seem to have any control. So when we decode these four connotations of power, control, participation, and choices, they are not isolated. They are interconnected. So when a person has limited power or has a power which is externally controlled, then there is a control and there is deprived participation or limited participation, limited access, therefore limited opportunity. Therefore, it is a situation of less of choices. Now, from this point of view, if you see, the concept of emancipation is where one is able to evolve within themselves and they redefine their reality. From women's point of view, or for that matter, any marginalized entity's point of view, where the embedding of that person in the system and their embodiment of their treatment are to be seen from these perspectives. So emancipation from within is not possible unless conducive empowerment from without, means in external conditions, are created. So from that point of view, the responsibility of law as an instrument of social change and as an instrument of justice, as a means to justice, becomes huge. Now, if this law is not something that has a voice of the woman, that has participation of the woman, whether in the form of participation in the legal system in decision making or in advocacy or in the lawmaking, as a legislator, as judge, and as a high-level lawyer who is responsible for changing the course of precedents, then automatically there will be a situation of imbalance or inequality. So from that point of view, the emerging issues in the world are, in last 2 decades, what we have seen is HDI index, United Nations special targeted programs through UNIFEM and United Nations Development Program, showing how women are years and years far behind the rest of the milieu in terms of important development indicators, whether it is in the form of access to education, access to healthcare, control of property, ability to have legal aid, to mention a few. Now, this is one parameter which is more in the line of what we call as development. Another parameter that we have is in the form of international human rights instrument. Now, if you look at the international human rights instrument, we know that in 1949, there was a United Nations Declaration of Human Rights, which was only a declaration with about 32 articles. And then we had division of this into civil and political rights, which are more or less the rights in the public sphere, which is rights against the state in terms of equality, freedoms, protection of life against the intervention of the state, right to legal aid if there is any allegation or any kind of confrontation with the law, or protection by the state of expressions, religion, properties. But on the other hand, there was another segment of rights which was recognized, which is economic, social, and cultural rights. Economic, social, and cultural rights are the areas which are very, very important in terms of quality of life, and they act supplementary to the civil and political rights in order to enable the complete or comprehensive attainment of justice and human rights. Now, in economic, social, and cultural rights, we have right to work coming in. We have in our social and domestic sphere the autonomy and the respect and the empowerment that is to be achieved. Now, it is in the economic, social, and cultural rights, women have a lot of difficulties. Now, what happened after the passing of covenant on these rights? Two covenants were passed by the United Nations Organization because there was a realization that Universal Declaration will not achieve its objective. And it is only a declaration. So the states were made to sign these covenants, two types of covenants. So they become the part of this whole global compact of human rights. Now, they were not enough because they were broad general duties. There were specific impact of or specific manifestation of these rights. If it came to women, the civil and political right was one issue, but the very enjoyment of that right was determined by the cultural norms. It was determined or underwritten by the social role that women played. So one cannot be independent of the other. Therefore, public participation and enjoyment of rights in the public sphere, whether it is political sphere or in eking a livelihood or living by means of economic activity, it necessarily was underwritten or it was controlled or underlined by social, economic, and political rights. If I was not allowed to participate fully in the workforce because I have to mind a small child, because it is considered that it is mother's responsibility, not that she is bearing that child for the family, and in child's life everybody ought to involve and she should be given that kind of opportunity and choice, is something that is going to be very, very determining as a factor. So here in private sphere, state cannot shy away. In public sphere, the culture cannot be non-influencer. Now, realizing this, particularly in different fields, we had specific types of human rights coming in. So rights protecting against racial discrimination came in the form of Convention on Elimination of Racial Discrimination. Then we had Convention on Children. As far as women were concerned, Convention on Elimination of All Forms of Discrimination Against Women, or the famously called CEDAW, came into existence in 1979. Look at the time, 13 years it took. However, post-1979, whenever United Nations conducted an audit of the functioning of this convention, first of all, majority of the countries had passed reservation, particularly on those areas where culturally women were liberated. Like, for example, they could determine their body, they could have their autonomy, they could have, wherever there was a conflict between culture and human rights, women's human rights had to be prevailing. For example, stereotypes to be eliminated, compulsory registration of marriage so that marriage does not become an exploitative institution. So all these provisions were blocked by the states by means of a provision called, or a process called reservation. So this was seen. However, in this light also, and alongside this, the important phenomenon that was observed, which is a reality in India even now, is violence against women. So United Nations constituted, in furtherance of this convention, special committees preventing violence against women. Now, interesting point is that when it is human rights, it is state vis-a-vis citizens. Therefore, any violation of these rights or any commitment of violence in the state-controlled sphere only became the focus under the generic human rights provisions. So they had to look at law from the point of view of specifically addressing such violations or addressing these issues under the general framework of the law, whether in the form of constitution or in the form of what we call as criminal law of the land, or in the form of tort law by compensating for the violation of these rights. So generically speaking, entire audit of the law from the gender perspective, particularly from the perspective of injustice to women, had to be seen, which required a new approach to law. So we saw in post 1979, committees after committees coming out with recommendation in looking at media, in looking at stereotypes, in looking at education, in looking at political participation of women. From the point of view of this discussion and this entire interdisciplinary seminar that you have organized, if we are looking at the commercial context, or if you're looking at the business context of human rights, there are very, very important developments that have happened, as you rightly pointed out, in the contemporary global times. What are those developments? If you allow me to tell two stories. I have one story of a woman who is working from home, and when she was working from home, at least when she was going to the office, she could organize her cooking and she could seek her husband's help and every family member's help. And then once she was out of the house in the office, what she did in 8 hours or something, and she came back. But when she was working from home, she had children during COVID-19. She had children to take care. Children were away from the school. Their studies was not being looked into. Getting them ready to sit in front of this camera and then giving them some kind of psychological kind of relief and warmth, and then catering to the needs of the husband, to the in-laws, and then also fulfilling the norms of her job, requirement of her job. So many women said that work from home was not at all a relief, it was more of a burden. And many women who work from home were also having new demands from their spouses in terms of cooking more meals because they were always hungry. Or during that time, new pregnancies and a lot of sale of condoms, etc., were observed if you look at the journalistic reports. Now, the most staggering phenomenon that came to limelight was almost 35% increase in the types of complaints that was received by the National Women's Commission through its helpline. Now, those women who knew how to use the mobile device and call, they used the helpline. But there were many women who had their perpetrator looking into their eyes and they could not call. So their parents would have called, their neighbors would have called. In Kerala, many neighbors brought the case to the attention of the police. So this is where work from home had become a kind of double-edged weapon. On the one hand, it was saving a lot of travel time and physical exhaustion. But on the other hand, it could do nothing for the mental exhaustion. We are yet to have studies to show what kind of resignation patterns, illness patterns have come during this period, which may indicate more data to this regard. Although people are looking at work from home as a great panacea for the traffic woes and for green economy, we have to put proper precautions and proper safety nets as far as imbalanced power relationship in home are concerned. I have a second story of this woman whom I know from a listed company. She was considered as a very efficient employee until recently. Some 7 years she has been working in this organization. In last 6 months, the whole department which she is handling is seeing a lot of complaints, delays, and they said quality aberrations. So when I checked with this woman, what she told me was that she was separated and divorced by her husband. She had a 7-year-old child to care for. And recently she has learned that, and there was a visitation right granted by the court. Indian courts are very particular about both the parents visiting. So even though he is younger, therefore she is the full-time custodian, the husband has the right to access. Now recently the child is flustered, which is affecting her. Now the flustered nature of the child is because the man has taken a second spouse. He has recently remarried and he is carrying this child to the house, and the child is observing them being close or some other environment, or he's not feeling loved, or he's feeling estrangement. So he's bringing that tension to the house, and this lady doesn't know how to handle it. Therefore, new age workplace, there are, in my organization, I had employees bereaving due to their parental death during COVID, or they would have had one of the spouses being far away in another country and not being able to travel back, or one of the close family members like kids or siblings. In these cases, some students have lost their parents. So here when we are looking at organizational health, and occupational health and safety, the need for mental health care, emotional well-being needs to be coming into the fore. Therefore, the very provisions related to policy and law in labor law as well as generic health need to be redefining organizational safety and health and environment in terms of including the mental facets and emotional facets in the emerging global challenges. The other emerging global challenge is poverty. Now, this global challenge, coupled with the gig economy's insecure work conditions, affects women the most, because they are the ones who compromise their job security when the child does not have a daycare facility, or when both husband and wife in search of greener pastures move to another city and they get a new employment and the lady becomes pregnant, then it is this child care needs which will take a toll on the woman. She makes the compromises most of the time. Whether the workplace ethics and workplace norms can facilitate pressures and all these compliances, gender-based compliances and gender audit of the organization is something that needs to be complied with. If you are looking at POSH Act, Prevention of Sexual Harassment at Workplace Act, Prevention of Sexual Harassment Against Women at Workplace Act, and if you see the series of decisions which are coming before the court these days, post the act, what is most interesting to see is that organizations are complying in terms of creating an internal complaints committee. They are complying in terms of sending the reports. There are appeals against the decisions which are coming before the courts. But what is most interesting is those who are suffering such harassment, whether all of them come in front, how does the organization facilitate helping the people to file a complaint? None of us knows the law if we are non-lawyers. Is there a complaints committee? Is there a legal advice available? Are there forms and formats to register the complaint? Is confidentiality maintained? How is the perpetrator and the perpetrated segregated? How is their mutual relationship going to be changing? Is there a bias in terms of segregating the two when the man is continued and the woman is asked to go on leave? So all these nuances need to be observed very carefully. Therefore, a gender-based or feminist studies deeply into these aspects as researchers and academics we need to do. In India, we came across very interesting contribution by academics on POSH, because it was the Justice Verma and Sakshi, the NGO, whose hard work resulted in the Vishaka guidelines in the Vishaka case in 1997. However, why did it take so long till 2013 to pass a legislation? And what happened in between? In between, even after this guideline, very few cases came before the court and very few organizations followed the guideline. This was brought to the Supreme Court by a public interest litigation by Medhalele, where the judgment came in 2012, and thereafter the legislation, there was a directive and legislation was passed. POSH Act was passed in 2013. But if you look at the review of the POSH Act, various organizations, they might have created an ICC, but whether there is an ecosystem which is putting women in leadership, which is enabling women to be seen more on the basis of merit than on the physical anatomy of being a woman, and her absenteeism, her lack of mentorship being addressed properly, and her work-life balance being seen with a sense of responsibility, not as a sense of chivalry, as a sense of specification, what we call as a differential treatment in a favorable way, in a very liberal way within the framework of the law. So law is not the only answer to such situations of human rights. Law needs to be seen in terms of being not independent of culture, because those who are in authority are also impacted by this kind of a patriarchal thinking. They need to open their minds. So such orientation, gender equality orientation needs to be given. So another issue that we need to see is the cyber online mechanism which we are using, and increasing victimization of women of trolling and cheating and misrepresentation, whether it is marriage websites or whether it is work related websites in the name of employment, women being trafficked, or a woman's social media presence resulting or being greeted by criminal elements, trolling continuing if it is a powerful woman having independent political views, victimizing such women and girls. is another dimension, which is a contemporary challenge with the cyber law. So this is a challenge I would like to address. And the last challenge I would like to say, aside from labor laws, indifference to women reality, or even where it is highlighted by things like transportation policies and safeguards for safety of women, we have multiple cases where non-compliance has constantly been happening. Women are forced to use Uber, Ola, and the drivers may misbehave. Or transportation companies have been outsourced without proper background check. So this kind of challenge. And the other one is tax policy. Tax policy, which is based on one's income, which doesn't take care of those women who are remaining out of work just to take care of a child or an elderly person in the household. So we need a very gender-friendly tax policy. If the public tax policy is not friendly, then the private sphere discrimination, private sphere need-related deprivation of women from the workforce and from the commercial life is something that cannot be addressed. So in the light of this, I would like to urge that we need to look at changing contemporary global realities, interventions in the form or developments in the form of technology, in the form of poverty. For example, COVID has pushed 33% more people into poverty. And whenever poverty is created, it is women who bear the brunt of the poverty. In the house, if there is less money, it is a woman who eats a smaller meal and feeds her children. Therefore, poverty's feminization, increasing poverty's feminization needs to be addressed by policy. And companies in their corporate social responsibility need to have a gender-specific project-related donations to be made, projects to be taken up, and within the HR department of companies, gender audit to be compulsorily conducted. And while submitting compliance reports through the multinational corporations or national corporations, please have gender elements like POSH and work-life balance and family-friendly environment and special leaves for women in the line of what central government gives in terms of childcare leave, even when children go for examination and things like that, need to be implemented. So my urge is that human rights are not just for the state, they are not just for the public corporations or government jobs. We need to have private sector also to be following human rights. One such attempt was made by United Nations Organization in John Ruggie report, which was incorporated into the general human rights agenda. I would urge within that CEDAW provisions to be also seriously looked into in terms of cultural shaming, cultural deprivation, subtle sexism, what Deborah Rod calls subtle sexism, that fat women. Women tend to get fatter in their 40s due to hormonal and thyroidal and polycystic ovarian disease and other reasons. These things don't come to men. So that sudden gaining of weight, depriving her of a position because she is not presentable, is also a very sexist way and discriminatory way of looking at things as per Deborah Rod. And they have won cases on such discrimination and deprivation. So in the ultimate analysis, I would like to say, women empowerment is for creating an equal society, and equality is about non-discrimination, and non-discrimination is about elimination of denial, exclusion, and exploitation. So let us see that all our enterprises, whether business enterprises, private enterprises, encourage and empower women to be equal participants in the workforce, in ownership, in decision-making, in power, in control, participation, and in making choices of life at par with men. Let's hope that our policies and our working and operations create such a conducive condition, and the years may see many, many women leaders emerging with this psychology and with this ethos ingrained into the organization, economy, and the world. Thank you very much for this opportunity. And I leave you with the warm greetings for the forthcoming International Women's Day and post-COVID recovery into a very happy and gender equal world. Thank you, one and all.
Thank you, Dr. Gurpur ma'am, for throwing light on various aspects on women empowerment by explaining us so efficiently. We hope to get your presence in the recent future soon. Now, to move forward, I would like to introduce our second dignitary, who is also our Indian resource person for today. Sorry, International Resource Person for today, Ms. Tatyana Nagiva ma'am, co-head of international arbitration of EPAM Russia. Ms. Tatiana is a graduate of the Kutafin Moscow State University and holds LLM degrees from the Manchester University and the University of Durham. She has an extensive experience of representing Russian and international clients both before state court and international arbitral tribunal. She specializes in the resolution of corporate conflicts and disputes arising out of construction of large infrastructure objects, as well as projects that require coordination of arbitral and state court proceedings in several jurisdictions at once. Ms. Naviva has many years of extensive supporting M&A projects too. I would like to tell you all that Ms. Tatiana ma'am has been listed in the professional rankings such as Legal 500, Best Lawyers, and Commerçant. I would now like to request Ms. Tatiana ma'am to please share her thoughts on this topic of the conference, that is women empowerment. Over to you, Tatiana ma'am.
Thank you very much for such a kind
very
introduction.
hearty welcome, Tatiana. This is Varsha Deshmukh. We keep talking, connecting with each other. Welcome to the conference.
Thank you very much. Can you hear me well now?
Yes,
Please, can you
yes.
confirm? Okay.
Yes, yes.
Yeah, thank you so much for this invitation, and I'm pleased that we have so many beautiful women today at this panel. And of course, we need to talk about women's empowerment in such a good company. Why we are talking about this now? I think it is quite clear, because we are all just want to make this world a better place to live. And indeed, women represent at least half of the Earth's population. They have their own thoughts, they think differently than men due to their social background, due to the role which they basically fulfill in this world while raising their children. And of course, women's contribution into arbitration is very important. And this is what actually the society and the arbitration community has recognized recently. I think that even social studies show that where women enter into arbitral tribunals, this may change the situation basically, because when people constituting the arbitral panel think alike, let's say that there are 3 men in the arbitral tribunal, they do not have this different perception which a female arbitrator can provide if enters into the arbitral tribunal. Therefore, now the arbitration community is working hardly on increasing the number of female arbitrators and increasing overall the role of female arbitrators in international arbitration. Indeed, there is a number of obstacles to this, and why do we see that female representation in arbitration community is lower than male representation? First of all, there are some objective reasons which can be coped with, taking into account the most recent development of IT technologies and increasing flexibility of working hours. And this objective reason is that many women just fall out of their profession for some time due to delivering a baby. And some female professionals choose not to have maternity leave at all, so that not to lose their opportunity in their career development. However, many women still prefer staying at home for at least several months or even several years. And indeed, they not only lose contact with their colleagues, but they also lose their visibility to the potential clients and to the potential nominators of them as arbitrators. For this reason, some of the law firms even suggest different programs allowing female arbitrators continue working from their homes. And basically now we see that, especially with the COVID-19 situation and with the development of IT technologies, that there is more flexibility for all of us. We can basically stay at home and continue working. And moreover, many arbitral institutions during the COVID-19 pandemic chose online hearings as an option. And basically, the entire communication was put online. All the submissions were made electronically. And for instance, ICC has immediately issued guidelines saying that they do not need physical submissions and printed submissions, etc. This means that even women on maternity leave can basically efficiently continue working because they can do this from their home, not getting separated from their children. And this is one of the factors which should help with increasing female representation in arbitration. But this is probably the most easy dealt with reason for female representation, for low female representation in the arbitration community. Whereas there are other grounds which are basically probably more complicated, and one of them is an unconscious bias. So we all understand that there is this unconscious bias. So this is a bias of our way of thinking, which we basically do not even acknowledge. Women are treated generally, unconsciously, as worse professionals than men. And this is a bias which is genuine not only for men, but also for female respondents. So we women perceive each other basically as worse professionals than men. And this is something we should deal with. Because in fact, women have their own talents, and a great talent may lay in a female human being, let's say. I'm sorry, Varsha, you are saying something, but I do not hear you. If you were saying something to me, please, can you unmute? Hello. Can you confirm that you can hear me, please?
Yes, ma'am.
Yes, yes.
Tatiana, ma'am, am I audible?
Okay, yeah. Yes, you are audible now.
Yes, you are.
Please
You're clearly
continue.
audible, ma'am.
Please continue with your.
Okay. So as I said, there is this unconscious bias, and what the community is working on, they're increasing the awareness of this bias. Because as long as it is unconscious, we do not notice it. But if we know that there is this bias, we start analyzing our process of thinking. So while choosing the arbitrator, we start thinking that whether I do not want this arbitrator to be appointed just because she is a woman. And this basically may also help us increasing representation of the arbitrators, female arbitrators. And finally, last but not least, let's say, is the visibility issue. As I said, many women prefer staying at home when they have spare time after their work and not investing in their business development and in the development of their personal brands, because they prefer spending their time with children once they have them. Whereas men continue attending conferences, publishing articles, etc., etc. They do not basically change anyhow their the style of their life at this point of time. And this is why they get promoted quicker. And the partnership for male professionals is more achievable than for female professionals. And what the community works on is that the arbitration community now provides lots of conferences, trying to ensure that female representation at these conferences is balanced. And basically, there is now a kind of positive discrimination in favor of female professionals. So everyone in the arbitration community is trying to increase and make even like greater representation of female professionals at the conferences. This is how these issues can be dealt with. And basically what we see, how the infrastructure develops for that. First of all, there is an organization which is called Arbitral Women. This organization exists already since 1993, but it became much more active probably more recently, since 2000, 2005. They have their own website, which also provides input into raising the awareness, and it basically provides an information source for people who want to see who basically these arbitral professionals, female professionals, are. They have a special database. So should you want to appoint a female arbitrator, you can go to that website, Arbitral Women, and you can find a relevant professional. Unfortunately, or maybe luckily, we all live in a free world, and we basically cannot force the parties to appoint female arbitrators. We cannot induce law firms recommending female arbitrators, but arbitration institutions, many arbitration institutions, now developed a strategy according to which at least their national committees have to choose a balanced arbitral tribunal and have to pay attention to the diversity issue when composing the arbitral tribunal. And apart from Arbitral Women, there is also another interesting organization, which is called the Pledge. That's also the Pledge for Equal Representation in International Arbitration, and many arbitral institutions signed this signed to this pledge. The goal of this pledge is also to improve the profile and representation of women in arbitration. This is the main goal, because actually this is how we all are improving this representation of female arbitrators in the profession, through the raising of their awareness and the kind of information propaganda of female arbitrators, let's say. And also basically this pledge, the arbitral institution which assigned to this pledge agreed that they will deal with the diversity within the arbitral institution. So their secretariats bodies, they compose in a balanced approach, and they have more female professionals than the others. Just a second, can you please come later? And so as I said, their national committees are also designated in a way so that they would increase the representation of female in this profession. And what we have to note is that all these efforts are not in vain, actually. So if we look at the statistics, and there is a very helpful report issued by International Council for Commercial Arbitration, they analyzed the statistics of representation of female professionals in international arbitration, and came to a conclusion that basically these statistics improved, substantially improved. But of course, they started from a very low level, and it was probably more or less easy to improve. But still, if we take, let's say, Stockholm Chamber of Commerce International Arbitration Institution, in 2015 there were only 14% of female arbitrators appointed, whereas in 2019 it was already 23% of female arbitrators appointed. So we see a sharp rise in the statistics, and overall the average statistics for all the arbitral institutions which were analyzed in this report increased since 12% in 2015 to 21.3% in 2019. So even though someone could think that this raising awareness and publicity does not have any impact on the situation, in fact it does, and this impact is substantial, as we may see it. I think that this is it for my presentation today. If someone wants to discuss something or ask any questions, I will be happy to do this.
Ms. Tatiana, ma'am, am I audible to you?
Yes, yes.
Yes. Actually, I had a question for you. Don't you think women were overworked during the pandemic? In India, reported cases to Women Commission was increased by 35%. What was the situation in Russia during the pandemic? And also, during the present war?
The situation with what? I'm sorry.
The situation of the women in Russia right now, presently, I may say. Can you please just throw light on that perspective?
Yeah, I think that there is no particular impact of these two events which you mentioned on female representation
Okay.
in the profession. Although it became much easier for women, as I said, to cope with the work-life balance, because they can now work from home and they spend more time with their families. What the COVID pandemic had impact on was the divorce rate, which I think is a kind of global tendency, because sometimes the spouses just cannot stay together for such a long time.
In India, the women were overworked because they had to look after family, children, and they have to pay attention to their work also. So it was a quite Herculean task for the women. And reported cases were 35%, and some of them couldn't reach to the commission for the complaint. Even the divorce rate is very high during the pandemic in India as well.
Yes.
Yeah.
Miss Tatiana ma'am, we have also a question from Jayashree Kanchanpuri ma'am, if she wants to please ask. Can we have?
Good afternoon.
Yes.
Good afternoon, madam. This is Jayashree Kanchanpurkar. Just want to know is if the government make it mandatory that one of the panelists in arbitration is a woman, do you think that the decision can be changed or something different solution can be there, or the government have to come up with the rule where the one of the panelists required to be a female?
I disagree with such a radical approach. Even that pledge which I mentioned, they also were considering issuing some mandatory guidance on this. But in fact, in this case, we just basically we cut on people's freedom to appoint the arbitral tribunal which they want, because this positive discrimination issue is a kind of dubious thing if we make it such a mandatory thing. Because if people cannot find a female arbitrator, this which would have relevant competences, this would make quite a great problem for them. And basically the arbitration depends entirely on the quality of the arbitrators which are in the arbitral tribunal. And this, I think, is only for parties to decide whether they want this arbitral tribunal to include a female arbitrator or not. Because for them, that's their core issue. They are in the arbitral tribunal not because they want to promote diversity, but because they want their dispute to be resolved.
Yeah. Actually, because in Indian society and all, we know that the mentality of the commercial, the offices now, they do not want a female to be involved in decision making. So that is why I feel that if we looking for some change in the decision, and if we want to empower the woman, we must give the chance to a woman that she can be involved in this kind of. That is why the question I have placed. But you are also very much correct, madam.
Yes, I think that we need to increase this empowerment. But as I said, I would rather prefer some soft power, right, being used, such as raising awareness, etc. The more you show yourself as a professional to the world, the more you take part in different conferences, the more you take part in business meetings with the potential clients, the more you increase the chances for you to be appointed. And basically, I have some female arbitrators on my list who have outstanding reputation, and all my male clients would always agree to appoint them, and they would never raise a question of, oh, you want to suggest a female arbitrator for me. No, I've never faced this kind of bias, right? The bias is unconscious, and it's basically when you start thinking of it, as I said, you realize that a female arbitrator is no worse than a male arbitrator. So the client, maybe if it had been choosing the arbitrator on its own, it would not choose a female arbitrator. But since I'm as a counsel, I can always cope with this bias of the client and show him a very decent arbitrator, a very decent female arbitrator.
Okay, thank you very much, madam. Thank you.
We have one more question from Nuzat Afroz. Yes, Nuzat Afroz.
Yeah, good afternoon, ma'am. My question to you is, what initiatives can be taken, as you said, to change the societal attitude and the corporate attitude as far as the appointment of female arbitrator is concerned? So what initiatives can be taken?
If you mean you yourself personally, then I think that if India still does not have the organization which is called arbitral women or women in arbitration, then you should probably establish one, because as we did in Russia a couple of years ago, just a couple of my colleagues did this, and this basically helped in terms of promoting this issue into the society. But this is, I think, that the best initiative, just to raise the awareness and to tell everyone that women are as professionals as men.
Thank you, ma'am.
Yes, thank you, Tatiana ma'am, for the solutions you gave, and you answered these questions. Thank you for your presence, your valuable presence. It was a pleasure listening you, and also we are overwhelmed by your presence. Thank you for being here, ma'am.
Thank you very much for inviting. Yeah, have a very good day and weekend. Unfortunately, I had to cut off because I have another appointment, but I hope you all have a pleasant day and very good conference, which is very, I think it's very well organized. Thank you very much once again.
Looking forward to, I mean, same appreciation and association ahead. Thank you so much.
Thank you. Bye-bye.
Bye.
Thank you. Our next suspected guest and our second Indian resource person for today is Dr. Sharmila Ghuge ma'am, who is at present working as a full-time associate professor at Jitendra Chauhan College of Law, Mumbai. Firstly, I would like to tell about Dr. Sharmila ma'am's educational qualification. She has secured her bachelor's degree in English literature. She completed her LLB and LLM from Aurangabad's Dr. Babasaheb Ambedkar Marathwada University. She also completed her PhD on Article 21 of the Indian Constitution, vis-a-vis right to die with dignity in rarest of the rare cases, a critical study. It will be of immense joy to share with you all that Dr. Sharmila Ghuge ma'am was awarded her PhD by the hands of His Excellency, former President of India, Dr. APJ Abdul Kalam. Moving forward, ma'am has published 3 books, which are Legalizing Euthanasia, a Pedagog's Perspective, which is a foreword by Justice V.R. Krishna Iyer. The second book is Surgical Strike for Population Explosion, a foreword written by Justice Jay Narayan Patel, former Chief Justice of Calcutta High Court. And the third is Unlocking Positivity, which is on positive approach towards life. Dr. Ghuge ma'am has been showered by various eminent awards recently, starting with the Best Researcher Award at National Conference Bengaluru, second being Best Researcher Award from University of Mumbai, and Research Excellence Award by Global Research Foundation, New Delhi. I would now call upon Dr. Sharmila Ghuge ma'am to please share her vision on this topic. Ma'am, over to you.
She is the soul of storms. She is the freedom of winds. She has the twinkle in her eyes. She has the moonshine in her smile. She is hotter than a volcano. She is deeper than the ocean. She has love mightier than the sky. She has emotions deeper than the sea. She breezes like the wind. She has lightning in her toes. She is the woman. She is the mother. She is the daughter. She is the sister. She is the woman. She is a human being. She is the woman. She is a human being. Please treat her like a human being. Very good afternoon, everybody. It's my pleasure to be amidst all of you today.
Good
on the
afternoon
occasion.
and heartiest welcome,
Very
madam.
good afternoon. Very good afternoon. Thanks for having me here today at this occasion, madam. Heartiest congratulations to the organizers, Punjab Rao Deshmukh College of Law, Amravati, and connected organizers, esteemed guests, speakers, and all dear students and faculty members. It's my privilege to be one of the speakers for the occasion of International Women's Day. Being a woman, as I shared my emotions to start off with, we have everything within us. So before I begin, I would like to ask whether I can share my screen and scroll through the PPT, or should I just go ahead extempo, whatever the organizers are happy with.
Your discretion, madam. Take your call. Yes.
Thank you. Thank you. So I'll just share my screen with you because I intend to make a imperative point here with regards to the Indian scenario of women empowerment, and which shows us that yes, we have walked steps ahead, but we have miles to go. And my friends, I will not take much of the time because I have no idea how the organizers look at my time limit, but I think, ma'am, is it 20 minutes or 30 minutes? All right, fine. So that my concern is that we should not exceed the time limit, having the international scenario, maybe speakers listening to us. Well, friends, I'm happy this morning I heard Gurpur ma'am, who expressed her views about women's empowerment, international scenario, the human index, also the recent speaker who spoke about the women participation in arbitration and etc. Aditi ma'am, your mic is unmuted. Could you please mute yourself? Thank you. So I'm going to quickly brush ourselves through the woman empowerment, the Indian experience. Well, what do we actually think of empowerment? Most of the people, learned people like all of you, think that empowerment has something to do of the professional life of a woman. I beg to differ on the point because I would like to see that a woman is not empowered only in terms of profession, but is emotionally empowered, is psychologically empowered. And that's the way we need to understand how we can be a contribution to women to be empowering themselves, not merely professionally, but in overall life. And that's what actually a person should look at. When we intend to protect the human rights, we should intend to look at the overall empowerment. So the outline of the presentation, which I'm going to proceed here, is quickly with few brief facts about India as a country, the place of women in the Indian society, the modern times scenario of Indian women, which we can go through education, employment, and empowerment, a few empowerment schemes which the Indian government has provided and is working hard on it, the role of Indian judiciary. Of course, the role of Indian judiciary means a lot for this discussion, and introspection as to where can we improve ourselves. So to cut down the longer facts short, my friends, all of we are aware of the fact that India is the second most populous country on the planet. And ladies and gentlemen, you will agree with the fact that it is the largest democracy of the world. Having said that, India's boundaries are surrounded by different countries, a country which holds unique culture over the years, over the centuries, is respected across the globe for its uniqueness, and also holds a humongous population crossing 135 crores today, and half of the population, ladies and gentlemen, is women. And therefore is the concern that goes for the planet. Most of the countries, rather, if you look at the international statistic, internationally, half planet owes women. And that is the ratio at present. Well, unfortunately, in India, the sex ratio of men and women is not perfectly balanced as per the population. The men ratio is much higher. Thus, being a unique country has a combination of various languages, religions. If we take a look at the historical perspective, well, it is said that the ancient era was the era of feminine glory in our country. And for the international students who are listening or who want to see this particular conference ever in future, if so, please note that in India, women have always been respected next to goddess as per the cultural and the philosophical thoughts. Unfortunately, so my friends, the modern era does not have the same traits, and therefore today we request women not to be worshipped as goddess but to be respected as a human being. So women plays roles like a mother, sister, daughter, wife. Everybody knows that. Her struggle is not new, whether India, whether any other country. We know that the struggle of women fight, struggle for women right has a very old history. If United States, if United Kingdom, Russia, India, all countries have the rich history, which shows that how women have struggled to get where they are today. In India, if we go back and count, we have a list of names starting from Savitribai Phule and running into many more ahead, who have taken efforts to make India what it is today, where we look upon our country as one of the superpower at the international level. And to succeed with that, we cannot ever forget the role of the Indian judiciary and the parliament and the policymakers. We have had a list of laws, plethora of legislations have been enacted in our country to protect the women, to empower the women, to eradicate the discrimination against women, starting from the abolition of sati. Many acts which I shall not read out, but the PowerPoint shall be sent to the organizers so they can pass it on for the viewers to go through. Domestic violence, dowry prohibition, medical termination. So we have a long list of laws which has been enacted from time to time as and when the need has occurred, till the sexual harassment of women at workplace, which was also a wonderful outcome of the 21st century. The suprema lex of this land, ladies and gentlemen, the Indian constitutional law. Indian constitutional law protects rights of women in every thread of the article which runs through the fabric of the constitution. And Article 14 talks about right to equality, 15 no discrimination, so on and so forth. Only one note to say that yes, the laws of this country focus on equality of women, which is the foundation of empowerment of the women, which is the foundation of securing the human rights of the women. However, what is the irony in the globe today, whether it is India or any other country, my friends, and especially so about India? The kind of society we have had in the past and are sailing through the future. The patriarchal society, the male domination. Somewhere in India, it still is observed in a day-to-day life. It's not that the patriarchal society has become instinct just due to the emergence of law. Unfortunately, that has not happened. I would have been happy to say that, yes, that has. So we have the male domination, we still have lack of education, we still have lack of empowerment, we still have lack of awareness. And how do we change that? Some time back, Honorable respected Gurpur Madam made a statement very beautifully that we must make efforts to empower women, and the efforts should come through law, the effort should come through society. I strongly agree with her, and I feel and I second the statement that social attitudes and social patterns need to change. Law is the strongest medium of social transformation. However, law plays a major role in molding the outer conduct of a human being. To mold the inner conscious of every human being, we need to have inner transformation. We cannot expect every country's government to do every little thing for that society. It's also the equal responsibility of the society, the people like you and me, to give in our bit and to make changes for the betterment of women in our society. So if we consider how times have changed, indeed, as I said, we have taken steps ahead, but we have miles to go ahead. Yes, my friends, we talk about education. Indeed, if we take a glance at the statistics in the year 1971 and if we take a glance at the year 2021, a gap of 50 years, we are happy to say that from 22% literacy of women, today we have walked up to 65% literacy of women. It is a matter of pride. However, to secure empowerment, we need to see that this is increased much more. The problem today is the gaps in education. Where does the empowerment get hindered in India? We have 100% attendance, 100% securement in the primary education and the high school education. The problem with India as a society is occurred in the higher education. So till the class 10th, we see parents very keen to educate their daughters. And the daughters also happily complete their 10th grade. However, as I said, we still live in a male-dominated society, and more so the rural society. So in India, 70% of this country resides in rural parts. And in rural India, people still believe, practice, I would say, girl has to get married as soon as she completes 18 years of her life. Well, recently, the age of marriage has been hiked in the country. However, for the people to accustom that, naturally, it's going to take more than a decade or so. Therefore, the result is, friends, the education of girls till 10th standard has a higher ratio, whereas the girls educating themselves in the higher education, like graduation and post-graduation, is merely 20% of the total educated girls. And that is the core reason as to why we see deficient empowerment professionally of women, because women are good in schools because they are allowed to complete schooling. However, they are not allowed to proceed with further education because of the social norms the family members have. Moving ahead to the barriers. Ladies and gentlemen, there are several barriers which come to female education. As I mentioned, the social values, the parental preferences, to get my daughter married at the earliest. Oh, I don't want my daughter to work. I'm okay with the 10th or the 12th standard education. She knows how to read and write. So today is not the era where we should look upon at reading and writing. We are bound to look beyond that. We are bound to empower women, not merely to educate. As employment is the next important step after education, which of course not only empowers her financially, but also to develop a personality of a woman in the true spirit of her dignity. Since the fallout in higher education is so less, the women in employment also are at a lesser percent. And in the informal sector, we have more women in India. However, the formal sector, we do not have those many women. As per the statistics, we have 16% of the total workers in the formal sector in the year 2020, friends. So the number has to increase faster. We cannot stick on to such a deficient number. As per the categories, as I said, categories of employment, if we look back 30 years, 20 years, 1999, for an example, we had agricultural harbor, we had cultivator, household industries, other categories. So in that, we have always seen female at a point more than male. If you look at the agricultural work, you will always see the laborer, women are more. The problem that means is women being mobile from villages to cities, women being educated beyond school to higher education, women being beyond the barriers of the social norms which unfortunately, are not in her interest. So that is where we need to work on. And the barriers, as I mentioned, cultural restrictions, discrimination, the cultural restrictions, of course, come up from the patriarchal society. The cultural dominations come up from the wrong notions. Though the culture of this country has very rich heritage of liberty of women and equality in the ancient era, however, due to external aggressions, there has been a change in thought process and lifestyle of this country. Discrimination at workplace is one reason, but the law takes ample care to protect a woman's right if that is the case. Empowerment of women, as I started off, should not be focusing more and merely on earning money. As I said, it should be an overall empowerment. Social empowerment, when we talk about, let her be educated, let her be confident of herself, let her voice herself. Economic independence is something which shall be given to a woman, which shall be acquired by a woman only when she is allowed to step out and earn. Today, we are thankful to the law of this land and to the judiciary of this country, which has made women economically empowered by giving her various rights which are attributed by the laws of this land. So today, women is not merely a homemaker, and woman is much more than that. Women are seen in all walks of life, whether it is driving a taxi, whether it's flying an aeroplane, whether it is working in the agriculture, whether it is working in NASA, whether it is working in a spaceship. She is everywhere. But the only concern is she is in a minimum number. So as women, on occasion of International Day, it should be an attempt to encourage more and more women, to encourage more and more men, to encourage the women. So it shouldn't be only encouraging the women, but it should be encouraging the men to encourage the women so that we have more women in all walks of life, including the political empowerment. Unfortunately, so for our country, being the largest democracy of the world, we do not have exactly the half participation of women in politics, which ideally should be the case, and we need to work upon that. There are several policies which the Indian government has framed for the empowerment of women. The empowerment policies run into a list which the government has enacted to encourage women, to further give that opportunity to the women so that women come forward and take the benefit. We have the National Commission for Women, which strives harder to make women equally empowered, to bring women in the streamlight so that they compete equally with men and they are totally self-sufficient. There are various legal measures which are recommended by the National Commission for Women, and that is how women in the country are helped even by the government. There are several steps which have been taken by the Indian government in the interest of women, from Beti Bachao, Beti Padhao Andolan, which means that you have to save the daughters and you have to educate the daughters. It is said that if you educate a man, you educate a man. If you educate a woman, you educate a family. See, that's the difference. And therefore, if a woman is educated, if a woman is empowered, that woman is certainly going to bring about a sea change in not just one family, but the entire generations to come. And therefore, it is very important for women to move towards the empowerment. I'll just take a couple of minutes and draw your attention, ladies and gentlemen, to the role of the Indian judiciary with very specific judgments which matter a lot for the women's right towards protecting her human rights and towards upholding her dignity as a woman. Well, the recent judgment, I would say, of the year 2020, Vineet Sharma versus Rakesh Sharma. So just to share with the international audience, India has always strived for securing equality of women. That's what the law of the land says, the constitutional law. However, the people of the country always had some confusions in mind with regards to the succession laws, whether a woman is entitled to be a co-partner of the family, the karta which we call of the family, and whether she holds the Hindu undivided family rights. And yes, my friends, in this particular case, the Honorable Apex Court of India very proudly ensured the rights of a woman in the Hindu undivided family. The court once again underscored, highlighted, and emphasized that every woman shall have equal co-partnership rights by the virtue of her birth, and it does not wave off or go away merely by her marriage. Equally, my friends, Shaira Banu versus Union of India was a wonderful judgment which came in, which somewhere stopped the practice of triple talaq. So a kind of welcome judgment by a secular nation as India. Moving ahead, we had another beautiful judgment which not only protected civilians but also women working in forces. The Secretary Minister of Defense versus the Babita Punia judgment, again 2020 judgment, wherein the Apex Court granted a permanent commission to women in the Indian Armed Force, which was missing till date. And the Supreme Court realized that this is must for women's protection. There are a few more cases, time is less, so we won't go through all of them. But yes, the moral of the discussion on the judgment segment in this particular presentation aims to accentuate the audience that Indian judiciary has done its best to uphold the rights of women on par with men, that's to secure equality. So Air India versus Nargesh Mirza was a landmark judgment wherein the Supreme Court again emphatically stated that women and men are to be treated equally and we cannot have indiscriminate laws for men and women. Muthamma's case also, wherein the Supreme Court intervened in the civil rules of the country, saying that the rules of Indian civil services should be equal for men and women. Devika Bishwas was a unique one. It's always said that, the whole world knows that due to the Indian culture, the women are always taking a step behind the man. But let me share with all of you very proudly, my friends, today India has changed. And today's India takes a step equal with a man. And we are happy to say that proudly. So this case was a unique one which focused on sterilization, the family planning program. India was the first country in the world to lead the family planning program in the year 1952. And India has had an unfortunate legacy to force women to get sterilized. But the Supreme Court again reminded this country that you cannot expect only women to go for sterilization. Even an issue like sterilization needs equality. The point here, ladies and gentlemen, is appreciate the concern of the Indian judiciary. It does not merely talk about the workforce, but it reaches to the nitty-gritty and intricacy of sterilization equality. So on and so forth, my friends. We have several judgments which have made attempts to secure equality towards the empowerment of women. The men work participation is indeed double of women, and we shall be very hopeful that women will certainly make it equal in the coming decade. So education-wise, ironically, India is still lagging behind. At the Human Development Index, yes, we agree and accept India still needs to make levels high to reach the Human Development Index and so the Equality Index. However, whatever said and done, we as women on the occasion of International Day should be proud of where we are and what we are, and we should take an oath that we shall further make our nations and the entire globe very proud of being born as a woman. The only thing what we need at present, every country has beautiful legislations. Every country has eminent facilities provided for women. But I'm sure most of the countries in the world are still facing issues like domestic violence towards women, crimes against women, injustice to women, and that is something we can change only by getting a social transformation from within. Every country has a beautiful set of laws, as I said, and therefore now there is time where we must make awakening of collective conscious. We must empower women by educating them more. Education does not again mean only in terms of literacy. For me, as a person of philosophical, spiritual thought process, I mean to say not only educate women in terms of literacy, but educate them in terms of their power as being born as a woman. I would like to state that a woman can manage everything much better than a man. I'm not trying to discriminate here between men and women, but if a woman can manage four things on her gas cooker, she can at the same time manage four things in her office. Men are very good at managing things in their professional lives. But if they are made to a test as it happened during COVID-19 pandemic, the men failed to do the tasks which women could. And therefore, we must appreciate the extra mark of the women. And for that, we just need to eradicate the discrimination which persists in the approach in the society. Therefore, the need is to accomplish gender equality, ladies and gentlemen, to uphold the rights of women. And let's not put this responsibility at the lawmakers, the lawgivers, the governments. Let's take this responsibility as ours. Let's look at society. Let's look at you and me. What is our contribution to the society? And the day we realize that, we may have a better world with more women empowered. As charity begins from home, let us be the first one to have such positive glimpses. We have several positive glimpses of India internationally where women have achieved wonderful achievements. But at the same time, we have walked steps towards, but we have miles to go. And for the miles to go successfully, we need to have not just deterrence of law, not just laws being enacted, not just judgments being pronounced, but we need our own awareness. We need our own contribution. We need sensitization of the younger generation. And that will take the society towards the transformation with change in the attitude, approach, and behavior of people, which will certainly bridge up the gap of ideals and reality. And in turn, of course, will protect women from inequality, empowering women not just in terms of words, but in terms of spirit. My dear friends, I would say, let's allow every woman to live a life full of liberty, equality, honor, and dignity. Thank you so much for the patient hearing. I'll be happy if there are any questions, ma'am. I'll stop the screen sharing. Yes, yes, please go ahead.
Am I audible to you?
Yes, yes, dear. You're very much audible. Yes. Go ahead.
Thank you, ma'am. Ma'am, first of all, thank you for motivating us with a wonderful structured explanation of yours on the numerous aspects of women in our society. Thank you very much. There is someone, Kiran Khandare, as our participant. She wanted to ask you something. Maybe we could just
please let her unmute herself and ask. Go ahead, madam.
Yes, yes.
Kiran Khandare, are you there? Are you there? You raised your hand.
Yes, she raised her hand. Is she there? Okay. I think something
maybe raised by mistake.
Yeah, by mistake.
By mistake,
sorry for that.
He must have raised a hand.
Yes. Sorry for that.
That's it.
Ma'am, we have Jayashree.
I think madam has included and everything. Okay.
Yes, if you permit, ma'am. we can just
Yes, yes, yes.
yes. Okay.
If there is no
Jayashree,
question, we will proceed ahead.
if you have a question,
This is Jayashree Kanchanpurkar.
yes, Jayashree Kanchanpurkar.
Yes,
Yeah.
yes, Jayashree ma'am, go ahead.
Madam, in today's society, I'm just want to know about the rights of a widow, because the law says that if a woman she is remarrying, then she cannot claim the property of her spouse, first spouse.
Yes.
I just want to know whether the same rule is applicable to a male, because I'm very much confused in this one. Because when we are saying that the woman equality, so a woman who lost her husband, if she's going for the remarriage, she cannot claim the property. But whether the same rule is applicable on a male party,
Yes. So say, for
that is my
example,
question.
yes. So thank you for the question, Jayashree ma'am. So if you look at it this way, that say Smita is a woman who was a widow and now she has remarried. Okay. So Smita has no right in her husband Rohit his property. Now you take an example that Rohit was married and his wife either dies or has a divorce, and now your case is widow. So Rohit becomes a widower, and now Rohit remarries, right? Your question pertains that will Rohit have right in whose property? The wife whom he lost?
Yes,
Obviously
yes.
not.
Do he have the right?
No, 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 not at all. How will he have right in the wife's property? Otherwise also, suppose Smita was the wife of Rohit and Smita dies. Rohit cannot claim anything in his wife's property which was not earned by Rohit and Smita. If
If it is earned by her Smita alone, that is her separate property. Because if it is ancestral property, then it will go back to the original.
yes,
But if it is her original, if it is her separate property, in that case, whether it will go back to her family or it will be taken by the husband who is remarried.
so if Smita has earned the property during the marriage with Rohit, then her property will go to Rohit unless there is a will which bequeaths the property to her parents. Then in that case, it also applies to the previous example. So for taking you back to the previous example, if Rohit dies and Smita is alive, and Smita's husband Rohit has left a lot of property, after marriage, Smita will take that property unless Rohit has bequeathed it to anybody else. But if it's ancestral property, then both do not have any right after marriages to claim in that property of that person.
Okay, so there is equality in such case.
Of course, there is.
And,
Thank you.
and one more thing I would like to add, this is the biggest flaw or irony of the Hindu Succession Act. Even the divorce or the wife during her lifetime, she cannot get the share in her husband's property. And unless the children she has, and if some woman is a issueless, she doesn't have any children, then she won't get her share in the husband's property. That is the biggest flaw, I think, area of the Hindu Succession Act.
Thank you, madam. Thank you very much.
Thank you.
Thank you, Sharmila ma'am. It was a pleasure listening to you. Thank you for giving your valuable time. I hope to have your presence in our college soon and to hear you once again. Thank you for giving such a wonderful opportunity, ma'am.
Thank you, ma'am.
Thank you. So it was a pleasure. Thanks for inviting.
Thank you.
Thank you. Thank you. Okay. Our next guest for today who is also our co-chairman for today's session. She is Dr. Anjali Thakre ma'am, principal of Sri Shivaji College of Physical Education, Amravati, an academician at heart and an athlete by soul, is a unique distinction of Anjali ma'am. Dr. Thakre ma'am has various achievements in her entire career, in which ma'am has been experiencing not only the world of an academician, in which she is not only publishing research papers of various topics, but also experience sports life by not only being a member of the men and women cricket team, but also being a player representing an organization. Dr. Anjali Thakre ma'am was represented as organizing secretary by UGC sponsored international conference and also was represented as the I'm sorry, I'll just do it again. Dr. Anjali Thakre ma'am was represented as organizing secretary by UGC sponsored international conference and also was represented for second international conference on physical education and sports science at Kuala Lumpur, Malaysia. She has 20 years of research experience. Ma'am has produced many journals on physical education and its various aspects. She has worked on different UGC projects. She has published 2 books, which are Khel Krida Disha Dishaye of Gauri Prakashan Amravati and Diploma in Elementary Education, NIOS Government of India. Dr. Thakre ma'am has also been the research person for various national and international conferences. Dr. Anjali ma'am has been also awarded the Best Researcher Distinguished Award in Bangkok, Thailand. So now, I may please request and call upon with all due respect to Dr. Anjali Thakre ma'am to convey her speech as a co-chairman.
Above all, let me add, she's international cricket cricket player, and she represented India in 1984.
Yes, ma'am. I was sorry, I was unaware of this. I was.
Thank you, Aditi. Thank you very much.
Yes.
Thank you, Valsha ma'am. First of all, I may pray esteem regards to founder of Sri Shivaji Education Society, great visionary, late Dr. Panjabrao alias Bhausaheb Deshmukh. I really congratulate daredevil dashing principal, Sri Shivaji College of Law, and her organizing team also, convener, co-convener, members, non-teaching, technical members, media team. Such a great organizing, burning issue conference. Sri Shivaji Education Societies, Dr. Panjabrao Deshmukh Law College Amravati and Centennial Solicitor UK jointly organized 2 days in multidisciplinary online international conference on emerging issues and challenges in human rights, commercial law, and women empowerment in contemporary global society. Today is the second day of international conference. Really, with me, Mrs. Dr. Shashikala Gurpur ma'am, Symbiosis College of Law. Then focused on Navina ma'am. She's from Russia, and last one Mrs. Guke ma'am. Really focused burning issue. Today's burning issue. Without much time, I have received some data from. I'm Dr. Anjali Thakre, co-chairperson of this session. I have received data from Dr. Panjabrao Deshmukh College. This online international conference got overwhelming response for research paper published in International Nebula Journal, G-Gate Index Research. Over 60 papers, good ma'am, where 60 research paper received, out of which 10 are commercial law, rest of women empowerment, 20 to 30 human rights, Article 16. The paper has covered the current global gender gap, the affirmative achievements with respect to women empowerment, and the analysis of National Family Health Survey 1920. Study of awareness among the unmarried Indian girl about NRA marriages, role of Indian judiciary in empowering rape victim. The right to social life of Afghan women requires political intellectual maturity of the Taliban. Afghan women need protection law to enable them to develop their individual and social talents and abilities throughout their lives. The post-trafficked situation needs to change as per the necessity to resolve the role of legislation, investigated agencies, and judiciaries will be the state of eradicated the menace of human trafficking. The awareness among the target groups and what sort of first help they could avail as it to be commonly known to all. The best model LDE maximum success shall need to be implemented effectively. Law awareness and training in developing enterprises in the field of anti-trafficking activities. At last, finally focused on empowerment in politics. How to show your leadership quality, how to handle the disaster management, how to solve the legal issues. Such a great conference, ma'am. Really, I am thankful. I am thankful to all the organizing committee members, and you have given me such a great opportunity me as a co-chairperson. Thank you very much. Thank you. Thank you. Thank you, Aditi. Over to Aditi.
I was on the mute, that's why I didn't.
Okay.
Yeah.
Thank you.
Yes, thank you, ma'am, for being here with all of us. It was indeed an honor to have you here with us. Thank you for your presence, ma'am.
It's my pleasure, ma'am. It's my pleasure.
Thank you, ma'am. Yes.
Thank you, Anjali madam. Thank you so much. Over to Vaidya madam now. Yes.
Yes, ma'am. I would now like to introduce our chairman for today's conference, Dr. Asmita Vaidya ma'am, who is currently working as the principal of Government Law College, Mumbai. She is a gold medalist and university topper at graduate and postgraduate levels, an MBA in human resource management, and a PhD in industrial law are some of Vaidya ma'am's qualificational achievements. Dr. Asmita ma'am has chaired many technical sessions and delivered many lectures as a resource person on different legal topics. She has organized many national and state level conferences, seminars, workshops, etc. She is a well-recognized supervisor for PhD students of RTM Nagpur University. To add to the list, Madam Vaidya has authored 8 reference books and 40 research articles in various national and international journals. More than 100 articles are published on women's rights in various newspapers. Ladies and gentlemen, please do take a note on this, that Dr. Asmita ma'am is also a vocal artist of Akashvani and is also a Sangeet Visharad. Dr. Asmita Vaidya ma'am is a recipient of many awards such as Tejaswini Award, Nation Builder Award, Navadurga Award, and a Superwoman and Best Teacher Award. I may now request Asmita ma'am to please guide us further with her speech.
Just add to it, madam is really a superwoman. Recently, she has organized Azadi Ka Amrut Mahotsav, was cherry on the cake. Lot of luminaries and stalwarts she has invited, and we are really blessed. She's a mentor in law faculty. Thank you. Welcome, madam.
Sorry, Dr. Asmita
accepting
an
invitation.
I have forget your name. Thank you for being at this session. Thank you.
Over to you, Asmita ma'am.
Madam, unmute yourself. Madam, unmute yourself.
Yeah. Thank you, Aditi, for giving introduction.
Thank you, ma'am.
Thanks, Varsha ma'am, for giving me this opportunity. All the legal luminaries who are present here online, I'm really feeling proud of being or chairing this session. And I'm really thankful to Varsha ma'am for giving this opportunity, because this women empowerment is one of the dearest subject on which I always like to have words. It was really pleasure in listening to Dr. Shashikala Gurpur madam, wherein she has discussed about the parameters of development and how the human rights has been used as an instrument to empower the women. She has also discussed about the international scenario regarding the position of women in detail, and she focused that human rights has been used as an instrument and talked about the women commercial empowerment by adopting the principles like equal pay for equal work and tax concession and so on. It was very nicely jotted down many important points by her. The second speaker, Ms. Taliana Navina, she focused on the women participation in unanimous. She focused on women participation in arbitration, and also spoke about the established unconscious bias regarding the women arbitrator. It is true that special efforts, they are required to have the female arbitrators, because that is a new concept and wherein we have already entered. The theme definitely have focused, and if we go through the different technical sessions, and the title of the conference, which speaks about the emerging issues and challenges in human rights, commercial law, and women empowerment in contemporary global society. I think many very important aspects regarding the women empowerment has been included. Dr. Shamila therefore have tried to cover all the legal aspects, constitutional aspects, and even the judicial aspects which have empowered the women to some extent. And I believe that when we talk about women empowerment, I believe that she do have inherent characteristics because of which she is very powered one. She is the second, in another word, we can say that she is the energy of the society. And therefore, when we talk about women empowerment, we have to cover the empowerment aspects in different ways. For example, social empowerment, economic empowerment, commercial empowerment, political empowerment, legal empowerment. And when we talk about this kind of empowerment, we have to understand what is the relationship between the law, women, and education. We all are here only because we have taken step ahead, and we can say that we are a little bit educated in our field. And therefore, as rightly pointed out, that education is the means through which women can be empowered. There are different reasons why there is a low literacy among the Indian women. As you all know, the samskaras of Hindus that after 16 or 18, the women, the girls, they are getting married. Then dropout rate of the girl, they are quite more. Even there are other reasons too. But at this point of time, wherein we have discussed all different aspects to empower her, and we have talked about the participation of women in arbitration, or participation of women in commercial field, or even in the empowerment provided by the law, judiciary, constitution to the women. I think we must focus on the challenges before Indian women and all women over the globe. Are we sure about our security? Security and crimes against women is the first challenge before us. The second one, acid attack. Domestic violence is another challenge. Dowry still exists. Female infanticide, it is still there. Sex selection, abortions, they are going on. Rape is a serious issue. Sexual harassment is another very serious issue which still exists, and we are still not able to curb that challenge. Trafficking, it's really horrible to go with the condition of a trafficking and number of increasing women trafficking. Even in the globalization, the new challenges, they are there before the women, like surrogacy. Live-in relationship is the biggest challenge we can see. Objectification is another challenge. And therefore, as rightly pointed out by Dr. Guge, that there are many constitutional safeguards, some directive principles has been given, states has been given the power to have the laws to protect the women. and lot many legislative measures are made. Now, how many laws are there to protect the women? Not less than 70 to 80 acts are there which actually deals with the protection of women one way or the other, and legal right is given to them. Now, at this point, as this part is covered by the other speakers, I would like to go with some steps which are required to make the women more empowered. What those are? As we all belong to education field, I think that value embedded women education is very much required. Creating new values is very, very important. Like, we never say that women or mother is the head of the family. We always say that she is mother, and head of the family is, of course, the father. So that kind of bias which still exists in our society should go away, and we must say that man and women or gender equality should be there, and mother and father should be given the same kind of importance. So that kind of values we will have to actually imbibe in our in education, and that should be percolated through education. Some awareness programs, just like the conferences and many other this kind of programs, they are definitely going to help for empowering the women who are still much away from the awareness regarding their rights. Similarly, some e-courses, they are required to be framed for the women. For example, she should be able to go with the e-factor, that is electronic media. She should be able to go with commerce, e-commerce, e-ticketing, and e-movement, everything. Entrepreneurial skills should be imbibed in the women. Self-help training is required to be given to her, and I think some important professional courses also should be included in the education. Then and then only, to some extent, we can say that women empowerment can go with this self-help and entrepreneurial courses. Most importantly, I think there is a need of reviving the security measures and rights of women to law. Strict implementation is required. Effective and vigilant efforts are required to be taken, and awareness regarding the rights and awareness regarding the protection which is extended to her should be made. As rightly pointed out by other speaker, that who is going to start? We ourselves will have to start with, and we will have to move with the fact that yes, we are empowered. Now, we, unless and until we ourselves think that we are empowered, we cannot move. Why I'm saying so? Because you just find out which is the office wherein we don't find a female. Every office do have women, because women have proved herself to be a good singer, to be a good director, to be a good actress, to be a good administrator, good doctor, good lawyer, and she is there in every field. She is there in every field. Even she is an astronaut, she is an astrologer, she is a philosopher, she is a researcher, she is a scientist, and she has proved herself. So partly, yes, she is empowered. But what is more required is that those who are not yet empowered women, we should give awareness to them, and we should make them aware regarding the rights available to them. The very important fact which we must understand is that we should respect towards the laws and recognition which is given by the society. We must respect that too. There should be no misuse of laws. We should understand what are the judicial efforts made for us, and we should definitely go, we should definitely respect all the facilities which are given to us. Now, at this point, as the theme also focus on commercial point, I want to say that some scholarships must be given to her. There must be some review of regarding these facilities, like commercial facts, I mean to say the scholarships and other facilities given to her so that she can be economically independent. And therefore, meaningful education to women encompassing the short professional courses, awareness, skill and entrepreneurial courses will definitely empower her more. Now, I am very brief in this because I think most of the topics or the subjects related to women empowerment has been covered either by the first speaker or the second or the third, and therefore at last I must say that women is everywhere. She is partly empowered, but many portion, many of the women still are in the pipeline. They are, it is our responsibility who are empowered, it is our responsibility that we should take the step to empower the other women. And therefore, I always say that the inherent characteristics of a women pays her sincerity, her punctuality, her determination, gives, empowers her. So I congratulate the organizers for organizing such a international conference on such very good topic. I also congratulate Principal Dr. Varsha Deshmukh Madam and the management, and I appreciate the paper and the presentations made by the resource persons. Thank you very much.
Thank you, Asmita ma'am, for giving such precious time of yours, and thanking each and every dignitary of ours as a chairman of the conference, and also sharing your vision on the topic. Thank you for all your best wishes. We are honored by your presence, ma'am. Thank you. Thank you for being here. And therefore, ladies and gentlemen, we are all arriving successfully to our destination. Thank you for your patience and valuable time. Now to conclude, I would like to call upon Professor Mahendra Ingole sir, our co-convener of the conference, to present their speech of vote of thanks.
Thank you, Aditi Thakre ma'am. Good afternoon, everyone. It has been such an honor to be a part of this wonderful and enlightening event of 2 days multidisciplinary online international conference of subject of emerging issues and challenges on human rights, commercial law, women empowerment in contemporary global society. Today is day 2, session 2. Friends, Cicero, a great thinker and philosopher, has rightly rendered some words. Quote, gratitude is not only the greatest of all virtues, but the present parent of all the others. Unquote. Friends, at the outset, I pay my obeisances to late Dr. Panjabra, alias Bhausaheb Deshmukh, founder, president of Sri Shivaji Education Society, Amravati, who provided us this immense academic platform so that we can conduct our international conferences on legal matters. First of all, I would like to thank Honorable Principal Madam, Dr. Varsha Deshmukh, who gave me an opportunity to submit vote of thanks as co-convener of this 2-day multidisciplinary online international conference, and it is a matter of honor for me. Friends, on behalf of Dr. Panjabrao Deshmukh College of Law, Amravati, and Sentinel Solicitors, United Kingdom, I would like to extend my heartfelt gratitude to our esteemed international resource person, Tatiana Naviva, ma'am, co-head of international arbitration at EPAM, Russia. I also extend my heartfelt gratitude to Indian resource person, Dr. Shashikala Gurupur ma'am, Director, Symbiosis Law School, Pune. Friends, I again extend my heartfelt gratitude to our third Indian resource person, Professor Sharmila Ghuge ma'am, Professor, Mumbai Law College. I extend my heartfelt gratitude to chairman of today's technical session 2 on women empowerment, Dr. Asmita Vaidya Madam, Principal, Government Law College, Mumbai. I also extend my heartfelt gratitude to co-chairman of today's technical session 2 on women empowerment, Dr. Anjali P. Thakre ma'am, for Principal Sri Shivaji College of Physical Education, Amravati. Sincere thanks to the staff of Dr. Punjab Rao Deshmukh College of Law, 3 years course, 5 years course, and post-graduation course, that is LLM. Sincere thanks also to the technical team who handled the event throughout. A wide round of applause and thanks to all the participants who made this event a memorable one. Finally, I would like to thank all of you present here for making the time to be with us today and helping us make this event a grand success. Thank you, one and all. Over to you, Aditi Thakur. Okay. Friends, with this, we have concluded technical session 2 and over to Dr. Radhika Deshmukh Madam for technical session 3 of day 2 on human rights. Thank you.
Good afternoon to one and all present here. Yesterday was a dream, tomorrow is a vision. But a day well lived makes every yesterday a dream of happiness and every tomorrow is a vision of hope. Carrying the same vision, we, the Dr. Punjab Rao Deshmukh College of Law, a family, successfully completed 75 glorious and tremendous years of its existence. With this wonderful thought, I, Dr. Radhika Deshmukh, faculty of Dr. Punjab Rao Deshmukh College of Law, Amravati, extend a very warm welcome to Honorable International Resource Person, National Resource Person, Chairperson, Co-Chairperson, and our respected Principal Ma'am, and all who are present here on this platform. In this Platinum Jubilee year, our college has been organizing 2 days multidisciplinary online international conference in collaboration with Sentinel Solicitor of UK. In earlier sessions, resource person had thrown bright light on the issues relating to the women empowerment and women equality, which is one of the 17th goal of sustainable development. Now, welcome back to this third technical session, which is based on human rights. For this, again, we have an international and national speaker to enlighten us on different aspects of human rights. Truly said by Nelson Mandela, to deny people...
Is Sajid Sheikh sir online? Kindly check. Preeti madam, kindly check whether Sajid Sheikh sir is online and he is made co-host. Yes, sorry for interruption, Radhika madam.
Yeah, it's okay. It's okay,
you please continue it up. Welcome, Smita madam.
Thank you, madam. Thank you very much.
Radhika madam, you can please continue. Huh?
Yes, ma'am. Truly said by Nelson Mandela, to deny people their human rights are to be challenged their very humanity. Yes, human rights are basic rights that belonging to all of us simply because we are human. They are an important means of protections for all of us, especially those who may face abuse, neglect, and isolations. Universal Declaration of Human Rights is a document that shouts across the world by leading countries in the world. Yes, stating shout and clear that no matter where we live, what we believe, or how we love, we are each individually deserving one of the most basic fundamental human needs. Human rights of every person are made a priority in the global theater. So I would like to give a pause to my short thought by quoting, there can be no peace without a development, no development without peace, and no lasting peace or sustainable development without respect for human rights and the rule of law. So I would like to give, I would like to request today's international resource person, the most distinguished personality, Mr. Sajid Sheikh, MD, Sentinel Solicitor of UK, who is an alumnus of our college and has given big support in organizing this conference. Sir, please address the audience on new trends in human rights.
I think Radhika, he has some technical issue to join. So I'm just waiting 2 minutes for him to join.
Okay, ma'am. Okay.
Yes. Anbhule sir is going to join. Kindly, yes, we'll wait for him to join by the time. You have to introduce Anbhule sir first. Then. Radhika madam, Anbhule sir would like to join first. By the time
yes,
we
ma'am.
Connect with the...
Ma'am, shall we play a video?
J.K. Collins, na? No, Anbhule sir is there.
No,
Anbhule sir is there.
Yes.
We will, I have requested him to continue with his lecture first, and then we shall continue with the Sajid Sheikh and then J.K. Yes, John Collins.
Yes.
Preeti madam, kindly check Mr. Anbhule sir is online or not. तो होता है ज्वाइन होता है few minutes, we shall see the opinion of, recently we have celebrated the 75 years of this institution. By the time the guest joins, we will play for 5 minutes, alumnus videos.
Hello friends, we are meeting after a long gap of time. I welcome you all on this auspicious occasion of Platinum Jubilee function. I remember those days of our law college. I have completed my LLB and then joined profession of law. The law college and other institutions are established by Dr. Bhausaheb Panjabrao Deshmukh, who had given us opportunity to the student of our Vidarbha region and all the sons of the farmers to get opportunity to stand on our feet. When I have joined law college, it was in old building. Our principal Sri D.R. Sinha and my senior and principal of law college, Advocate Mr. H.Z. Patil, given us training to stand on our feet and to face any situation in our life. Those days are beautiful. I have appointed as a lecturer in law college and got opportunity to study law and to teach law. I am grateful to Dr. P.D.C.L College, Amravati, for giving us me opportunity to stand on my own feet. Thank you very much.
Dr. Marsha ma'am, your mic is mute. Please unmute yourself.
Both the resource persons are online. I request Sajid sir to be online. Sajid Sheikh sir. I think James Collins sir is also online. Kindly put on your videos. We request you to put the videos on.
Ma'am, shall I call Sajid sir again?
Yes, yes, please.
Ma'am, shall I invite Amure sir?
Yeah. Have you made them co-host? Have you made them co-host?
Yes, ma'am. Ambule sir.
It's Mr. Anbule sir. Yes, yes, sir is online.
Yes. Good afternoon, sir.
Good afternoon.
It will be my honor to invite National Resource Person, Advocate Dr. Rajendra Anbule sir, AOR of Supreme Court of India. He is Chief Coordinator as well as a resource person for Bar Council of Maharashtra and Goa and working with many welfare associations. He had filed a number of PIL in Supreme Court and High Court. Sir is here to address us on clean, healthy and sustainable environment as a universal human right. Over to you, sir.
Thank you very much. At the very outset, I am very much thankful to Dr. Varsha Deshmukh for giving me an opportunity to address this conference on the topic of clean, healthy and sustainable environment as a universal human right. It is said that the concept of right is developed parallel to natural law theory. And the concept of human right has been emerged after the Second World War, when United Nations was established in 1945. But it can be said that the right to healthy environment as one of the human right was never a priority before the international organizations or even United Nations. But over a period of time, I think human right agenda has come to include the right to clean and healthy environment. Today, clean, healthy and sustainable environment has been treated as a third right of human right generation And very importantly, today this right is an emerging concept and is hotly debated in human right arena. A healthy environment is essential uh, aspect of right to life, violation of which is violation of basic human right. And not only the United Nations has clarified this in 2021, but at the same time, uh, even various state parties has also recognized this particular right as a basic human right. As far as India is concerned, uh, after Menaka Gandhi versus Union of India, which was decided by Apex Court in 1978, uh, the human right jurisprudence has been increased and widened in leaps and bounds. And so many rights relating to environment has been incorporated by Apex Court in the list of Article 21. Uh, so far as the judgment of Apex Court in 1991 in Subhash Kumar versus State of Bihar is concerned, Apex Court has clarified that pollution-free water and air is a fundamental right under Article 21 of the Constitution. And after that also, we may say that the concept of life under Article 21 is used in diversified manner in India by Apex Court in so many cases, wherein it includes right to survive as a species, as well as right to quality of a life, even right to dignity, and even right to livelihood of a human being under Article 21 of the Constitution. Now, as far as development of this particular right is concerned, it can be traced to 1972 when the Stockholm Declaration was there. So, right to healthy environment in international arena was developed later uh, or gradually. And firstly, it was recognized by the Stockholm Declaration of 1972. Now, if we consider principle number one of this declaration, it says that a man has a fundamental right to have adequate conditions of life subject to protection and improvement of environment. And if we see principle number 8, 11, and 18 of this declaration, basically principle 8 declares the guarantee of quality of life. Principle number 11 discusses about better living, and principle 18 discusses about common good of mankind respectively. So very importantly, again, principle number 21 is also there, which discusses about state sovereignty to exploit natural resources subject to the condition not to damage the environment. So herein, if we see the Stockholm Declaration, it basically speaks about the concept of sustainable development. And up to Stockholm Declaration also, the Rio Declaration of 1992, again tried to discuss the aspect relating to clean, healthy, and sustainable environment, wherein in principle number 2 of Rio Declaration also, it has been discussed that the right to pursue environment and development policy is a right available to everybody. And principle number 4 also clarified right to development, stating that it must be fulfilled so as to equitably meet uh, development of environment pursuant to the future generation also. But if we compare Stockholm to Rio Declaration, we can say that Rio Declaration affirm less concern for sustainable development so far as the content of that particular declaration is concerned. Now, if we see new development which is there at international level in relation to clean, healthy, and sustainable environment as a basic human right, on 8th of October 2021, United Nations declaration has come, and United Nations has adopted a resolution. And this resolution has declared clean, healthy, and sustainable environment as a human right on 8th October 2021. Even though there is late or there is delay in declaring clean and healthy sustainable environment as a basic human right on the part of United Nations, we can say that this right is already recognized in several countries. The resolution still has paved the way for effective, we may say, integration in international law and even a stronger implementation of this particular concept domestically. Uh, I may state here that Portugal was the first country to enshrine clean, healthy, and sustainable environment as a human right. That too in 1976, in their constitution. Since then, this particular right has been rapidly spread over other constitutions. Before coming to India, it is very important to discuss the concept of sustainable development, which was part and parcel of the Stockholm Declaration of 1972. And even in India also, so many landmark judgments are passed by Supreme Court of India, wherein this particular concept has been discussed in relation to human needs as well as even the protection of environment. As far as concept of sustainable development is concerned, we can say that sustainable development is a concept which endeavor for integration between environment and development. Sustainable development is contained in Stockholm Declaration, but the plain meaning which can be discussed here is that there cannot be any kind of development at the cost of environment. And very importantly, if any need is there in present, that need can be met, but at the same time, it shall be met without compromising the need of even future generation. As far as objectives are concerned in relation to sustainable development, the object of sustainable development is economic, even social, as well as environmental. The economic object of sustainable development is to produce the goods and services for the citizens. And environmental object is the preservation of natural environment. And the social object of sustainable development is the quality of life which is to be provided to the people by that particular legal system. Now, so far as India is concerned, as after the commencement of the Constitution on 26th of January 1950, Part 3rd and Part 4th of the Constitution has given elaborate list of directive principles as well as fundamental rights. Article 12 to 35 discusses about fundamental rights, while rest of the article till 51 discusses about directive principles. To achieve the goal of directive principles, which are there in Part 4th of the Constitution of India, there is no alternative to the development. So in India, what we need is the sustainable development. And if we see Article 38 and Article 39 of the Constitution of India, which is part of directive principles of state policy, we can say that if we want to achieve the goals mentioned in these two articles, there is a need of sustainable development, and there is no alternative to the development. So this development, which is a need of the day, cannot be there at the cost of the environment. Before discussing what the Apex Court has tried to lay down in relation to this particular right, which is enshrined now in Article 21 of the Constitution, let me clarify the scheme which is provided in Article 38 and 39. In relation to Article 38, the concept of welfare of people has been emphasized. And this welfare of people is in relation to social, economical, and political aspects. And it has been stated in clause number 2 of Article 38 that it is the duty of the state to minimize the inequality of income as well as status. And again, Article 39 discusses about certain principles to be followed by the state, wherein the first important aspect is there, that is adequate means of livelihood. Secondly, distribution of material resources for common good. This second aspect is very material in relation to sustainable development, because 39 deals with distribution of material resources for common good. Again, equal pay for equal work is there. But after that, health of the worker and development of children is also one of the part of Article 39. So with a view to achieve the goals mentioned by these two articles, sustainable development is very important in India. And as I said earlier, that there is no alternative to the development. As I said before some time that in India, Article 21 has been widened by Supreme Court of India post Menaka case after 1978. Supreme Court has even put right to clean and wholesome environment to higher pedestal. And the Apex Court has clarified in so many cases that life includes even a healthy environment. So for this, Indian Supreme Court, I may say, is far ahead from its counterpart in other countries. And Indian Supreme Court has tried to, we may say, interpret the rights relating to environment under the canopy of Article 21 of the Constitution of India. So there are so many judgments wherein category of cases court has tried to evolve and interpret right to environment vis-a-vis Article 21 of the Constitution. I may refer to one of the judgment of Supreme Court which is given in 1985, that is in rural litigation and entitlement versus state of Uttar Pradesh. In 1985, when this judgment was given by Apex Court discussed the issue relating to development, also issue relating to human health and ecology. And these three issues were in focus, where Apex Court has clarified that where human-sponsored industrial advancement uh, place the right of every citizen in jeopardy, then the court will not hesitate to close down that particular operations. So in rural litigations and entitlement versus state of UP case, Apex Court has clarified that industrial development cannot be there at the cost of the environment. And if any activity is conducted by any particular, we may say, entity which is going to put any danger to the environment, or if there is a threat to the environment, then Supreme Court will come forward and it will not even hesitate to close down that particular operations. So I may say that in the judgment of 1985, that is rural litigation, Apex Court has tried to protect environment by curbing even those activities which are causing threat to it. After that, in 1987, after rural litigation case, even MC Mehta versus Union of India was decided by Apex Court, wherein healthy environment has been held by Apex Court within the meaning of right to life. So this is nothing but blurring the distinction between environmental rights and right to life, which is there in Article 21, wherein Supreme Court has tried to include Article 48A of the Constitution in Article 21. This is nothing but bridging the gap which is there in Part 4th and Part 3rd of the Constitution. After rural litigation and entitlement case of 1985, and even MC Mehta versus Union of India of 1987, again Apex Court of India has tried to discuss the law relating to sustainable development in MI Builders versus Radhesham case of 1991. In MI Builder case of 1991, even Apex Court went further and clarified that if any structure is there which is detrimental to the environment, then Supreme Court will not hesitate to pass an order to pull it down. So even any particular structure which is inimical to the environment can be even demolished according to the order of the Supreme Court in MI Builder's case. After MI Builder's case, we may say that one important development has taken place in 1996 when Velora citizen case was decided by Apex Court. And I think that Velora citizen case is one of the landmark case in the area of this particular sustainable development and even clean and healthy environment as a universal human right. In Velora case, Apex Court has not only discussed the concept of sustainable development, but at the same time, our court has tried to rely on the Rio Declaration, and court has tried to develop the theory that economic development cannot be allowed at the cost of environment. And court has tried to discuss some salient features of sustainable development, wherein firstly, Apex Court has clarified in Velora case of 1996 that environmental protection is one of the basic features of sustainable development. After environmental protection, use of natural resources is one of the basic features of sustainable development. Even conservation of natural resources has been regarded by Apex Court as one of the important features of sustainable development. In this particular case, even Apex Court formulated and invented one new principle, that is precautionary principle, which is very important in environmental law. And according to Apex Court, even this precautionary principle is also one of the important facets of, we may say, sustainable development. And along with this, even eradication of poverty has also been outlined by Apex Code as one of the features of sustainable development. Uh, at the same time, when this particular judgment was given by Apex Court in Velora case, 1 year before, even Apex Court has discussed another important judgment, that is State of Himachal Pradesh versus Ganesh Wood Product in 1995, wherein also Supreme Court of India has tried to discuss doctrine of sustainable development, wherein Apex Court has clarified that the present generation has no right to deplete the existing forest and leave nothing for the next future generations. When Apex Court held this in Ganesh Wood Product case, Apex Court wanted to clarify that whatever resources we are having in hand should be utilized for the benefit of present generation, as well as they should be even kept intact for even future generations also. Despite the fact that Apex Court is trying to create a law in absence of any particular legislation, though certain parliamentary legislations are there to protect the environment, Apex Court has always tried to let down something new with a view to protect this particular human right under the canopy of Article 21. Even though this is so, the balancing process of sustainable development has found some difficulties in India when Narmada Bachao Andolan case was decided by Apex Court in 2000. In 2000, when Narmada Bachao Andolan matter was decided by Apex Court, Apex Court specifically laid down that any individual in garb of public interest litigation cannot challenge the policy decision, particularly where the massive projects are undertaken by the state and hundreds of crores of rupees of public money have been spent on it. Even though we may say that Narmada Bachao Andolan case is to be treated as a case wherein Apex Court has tried to let down law in favor of the state, despite that we cannot ignore the contribution of Apex Court, wherein Apex Court has tried to develop law relating to environment within the meaning of Article 21. So if we see the scheme which is there in Part 3rd and Part 4th of the Constitution, we may say that Part 3rd is justiciable in the court of law under Article 32, because Article 32 has provided a right to constitutional remedy. But Article 48A is there, which deals with protection of environment, which is not enforceable in the court of law because of Article 37. It is because Article 37 of the Indian Constitution says that directive principles are not enforceable in the court of law. Despite that, they are fundamental in the governance of our country, and it is the duty of the state to apply these principles at the time of application of laws. Even though this is so, as Article 35 to 51 are not enforceable in the court of law, and we cannot file writ of mandamus in Supreme Court or High Courts for implementation of this particular Part 4. Despite that, Article 48A has traveled from directive principles to Article 41. And as I said earlier, that in Subhash Kumar versus State of Bihar, Apex Court held that pollution-free water and air for full enjoyment of life is included in Article 21 of the Constitution of India. Here, Supreme Court wanted to say that right to environment is enforceable under Article 21 of the Constitution. So, even though Article 48A was not enforceable in the court of law because of Article 37, today, due to Subhash Kumar case and other judgments which are given by Apex Court, now a clean, healthy, and sustainable environment as a basic fundamental right is now enforceable under Article 21 of the Constitution. We may say that this is nothing but bridging the gap between these two articles. So, even though clean, healthy, sustainable environment as a universal human right has been recognized by United Nations on 8th of October 2021, when UN declaration came there, and United Nations adopted a resolution. Before that, India as a state has recognized this right as a basic fundamental right under the canopy of Article 21 of the Constitution. We may say that this is nothing but bridging the gap between part 3rd and part 4th of the Constitution, wherein this new right has been developed by Apex Court in Article 21 of the Constitution of India. So, very importantly, not only at the international level, but at even state level also, and particularly in India, so many new, we may say, rights have been derived in environmental rights, wherein a new list has been created by Supreme Court of India. It may be in relation to protection of forest, it may be in relation to protection of wildlife, it may be in relation to pollution-free water, or it may be in relation to pollution-free air. Apex Court has tried to connect that with full enjoyment of life, and it is with a view to right to survival, even the quality of life, and even right to dignity and right to livelihood. So, as a we may say that guarantor of human rights, Apex Court has tried to keep flag of humanity waving all the time in India by incorporating even this new right of regime under Article 21 of the Constitution. So, Indian development of environmental law in relation to clean, healthy, and sustainable environment as a basic human right is in consonance with the right which has been now recognized by United Nations by passing a resolution on 8th of October 2021. And I think that in future also, this particular law will be developed in leaps and bounds, and Apex Court will create some new rights under the canopy of Article 21 in form of this particular environmental rights. I am very much thankful to Professor Dr. Varsha Deshmukh for giving me an opportunity to address this international conference on clean, healthy, and sustainable environment as a human right topic to me. Thank you very much.
Thank you, sir.
Thank you, sir. I would like to say one line for Anbule sir. Star shine at night, some star shines at bright daylight. It's our immense pleasure to have such a star with us who is influencing us with these eye-opening words. Sir has thrown light on how the environment law in India is meeting with the sustainable development. I would like to thank you with a big applause, sir. Thank you so much.
Thank you. Thank you very much.
Now, I would like to request today's international resource person, the most distinguished personality, Mr. Sajid Sheikh, MD, Sentinel Solicitor of UK, who is an alumnus of our college and has given a big support in organizing this conference. Sir, please address the audience on new trends in human rights. Over to you, sir.
I hope you can hear my voice now. I just
yes, sir.
You can.
Yes, sir.
Okay, thank you very much. Well, I'm grateful to Dr. Panjabrao Deshmukh, College of Law, Principal Dr. Varsha Deshmukh, and all of you who have organized this event, which is I'm quite pleased to be part of it. As I said in my visit to India earlier on, that I'm fully committed to assist and help Dr. Panjabrao Deshmukh College of Law in whatever way I can help, and particularly the young boys and girls who wish to become a lawyer. And we want to create a very fantastic and reliable and ethical lawyers in our society, and we want to help them in any way possible, simply because we were helped by our seniors, and I am proud to say that I am a product of the institution, which is Dr. Panjabrao Deshmukh College of Law, which is I'm so proud of it, because Dr. Panjabrao Deshmukh, there are very few people like him in this entire world, because I am also a student of history. Shivaji Education Society, I am so grateful to Dr. Harshvardhanji and all of you. Before I talk about human rights and my experience and what's happening right now, it was my duty to convey my gratitude to all of you. As some of you might be aware that I was practicing lawyer in Amravati and Nagpur High Court, and I left around 1991 to go to the United Kingdom. Before that, I had hardly touched upon any human rights kind of claim. When I say this, it's not entirely correct, because I believe and I have seen that there are so many articles in the Constitution of India which provides human rights to all citizens of the country, and you know, those of the students who are listening to me, I must say that, look, I have read various pieces of legislation and laws across the world, but I must say that Indian Constitution is one of the most beautiful piece of work. I cannot praise those who have drafted it enough. And it's a wonderful, I mean, even UN Convention, most of it is already there. When UN Convention was adopted in 1950, similar time our Constitution was enacted. So it all points to the fact that our lawyers who created this document were very much aware of all these issues. Anyway, now coming to the point of introduction to human rights, as far as my experience goes, I first came across a case in the United Kingdom. I was working for a firm of solicitor as a junior lawyer, and somebody came to me, and he was a new client, and he asked for me to apply for asylum on his behalf. It was a bit shocking for me at that time, because before I came to United Kingdom, my understanding of asylum was that if you are a leader of a particular country and there is a coup in the country, or military takes over, whatever, you go to another country and seek asylum. That was my understanding. I mean, because I had seen it. Shah of Iran went to United States for protection. Similarly, Idi Amin from Uganda went to one of the Middle Eastern countries for protection. So I read that. Anyway, when I looked at the details of his claim, then I understood what is the importance of the protection that is granted by UN Convention. And that is when I understood the importance of it. Because I did not believe this client. Why is he claiming asylum? He was just an ordinary guy from Somalia, a country, remote country, and he was a poor man. I could not believe that, you know, how it is. But that man showed me evidence. And I would like to share that with all the young people who are watching this. It was an eye-opener. He showed me a video from his country to justify or to demonstrate why he is entitled for protection in the United Kingdom. Now in this video, I must tell you, this was from Somalia, and this video was officially recorded by somebody there. In this video, how people are persecuted, how they are harassed or tortured or killed, it was all documented. Now, I'll give you just one example of it. That example is, there is a majority community in Somalia, which is in Somalia, it's all about clans. Means different clans have their own hierarchy. So the majority clan used to persecute. In Indian language, I would say कि जो majority के लोग थे वो minority पे अत्याचार करते थे. That is in a nutshell. And in this video, I saw that the majority clan leaders were holding courts, for example. So a person is accused of a crime of theft. He was brought in. This is within 5 minutes. He was brought in, and the courts, without listening to any evidence, any trial, anything else, they would convict him, and then the conviction was to cut his hands off, and they will take him immediately within half an hour to cut that person's hands off. And it was shown on the video. I have seen that. This is what this protection or human rights, which we deal with and where we are involved. Similarly, I saw a trial where somebody was accused of a crime which was punishable with death. Within 1 hour, the guy was tried, and within 1 hour, he was executed. It was shown in the video with the timer on. And that is when I committed to working or helping or providing protection to these vulnerable people who came from various countries, people from African countries, people from Turkey, people from nowadays Albania, many countries, Sierra Leone. So my clients have been from all over the world. Now coming to human rights, we are mainly concerned with the protection which is given in the UN Convention 1950 and which was enshrined in European Convention of Human Rights. So we work within those ambits, and this has various articles. For example, Article 2 is right to life, which is absolute right. Then we have Article 3, which is prohibition against torture, cruel or inhuman, degrading treatment. Now, this is very important article. Article 3, most of the cases which we came across invariably involved Article 3. Because people were persecuted because of their race, because of their clan membership, because of their social group, because of their membership of a particular group or their religion. On these basis, these people were persecuted. And the persecution can vary between detention, torture, harassment, and it goes on to rape, detention, and even death, killing people. And that is where the UN Convention 950 or European Convention of Human Rights provide protection, and it is the duty on all the signatories in the of these conventions to provide protection. United Kingdom, all European countries, America, many countries, 100+ countries are signatory to this convention. And we dealt with many cases along these lines. Human rights law developed in the United Kingdom in and around 80s and 90s, but the peak of it was in 2000. Fortunately, we had the best jurists, best judges in the House of Lords, who were very clear, and they were, I would say, I would take one or two names: Lord Bingham, then Lady Hale, Baroness Hale. These people were one of the finest jurists of the entire century, and because of them, this law developed in the United Kingdom leaps and bounds. We were part of the system where we took these cases to the authorities, and if authorities refused to provide a relief which is required, we could then go to court. So we have taken a lot of these cases to higher courts, including Court of Appeal, High Court, first High Court, then Court of Appeal, and then House of Lords, which is nowadays is renamed as Supreme Court of England and Wales. There is another right as far as convention goes, right to marry. Everyone has a right to marry, and any public body or public authorities cannot prevent anyone from marrying as per their choices. I want to just discuss about this particular right in a very brief manner, because this was one of our cases which went right up to the House of Lords. Basically, in early 2000, the United Kingdom government came out with the legislation by which if anyone who is subject to immigration control, or in other words, who is an immigrant who came to the United Kingdom and they want to marry, they needed to seek permission from the Secretary of State for the Home Department, means Home Minister for in Indian context. So they needed to seek permission from the Home Secretary, and we, as a lawyer, along with many of my colleagues, one of them, Mr. James Collins, will be joining us soon, and he will be sharing his experiences with you. We thought this was a very draconian law because, you know, in a civilized society, you cannot make a rule or legislation that prohibits you from marrying a person of your choice, and you need to seek permission from somebody, which we did not accept. And it was designed to stop immigrants from marrying and trying to stay in the United Kingdom. That was the intention. So we took that case to the High Court, where we won. Basically, the High Court came to a conclusion that this cannot be, this is not correct law, it is draconian, and such law cannot exist. But the government was hell-bent upon, you know, making, they wanted it their way, and they went further ahead, and they went to Court of Appeal. Fortunately, we were successful there as well. The government did not stop there. They went to Supreme Court, or as we used to call them in those days, House of Lords. So this was a very contested matter, but we continued with our fight. In the House of Lords, again, we won, and that law was quashed in a way. The government finally accepted their defeat, and they threw away or tore that particular piece of legislation. But the point here is this: how can any government or a public authority infringe upon the rights of individual in such a way that they will decide who can marry and who cannot marry? Similarly, there was also one provision which was absolutely discriminatory. For example, in that legislation, in that particular law, the provision was that it will not, everybody must seek permission, all immigrants must seek permission from the government before they can marry, except if you marry in Church of England. That is what it really means. If you are a follower of Church of England, then you don't need permission, you can go and marry, even if you are an immigrant. But if you follow any other religion or any other church, for example, or any other religion, then you must seek permission. So that was a blatant disregard for human rights, and in absolutely discriminatory in every way you look at it. Fortunately, we won that case. But let me tell you one thing, you know, the young lawyers, I don't want to like go into the details of, you know, the technicalities of the law and the pieces of legislation or case law, but I'll tell you one thing. When you take up cases like this, you will go under tremendous pressure. We were pressured by the government in very, very different ways. They tried to intimidate us. They tried to bribe us in a way. They tried to put pressure on us by sending undercover journalists and trying to see if we say something which can go against us. So things like that happen. The authorities who want to disregard human rights, they may not stop just at the point of creating legislation. They may go much, much ahead, and they want to ensure that people do not raise their voices. This is where the lawyers come into the picture. This is where you and I, we are involved. And it is up to us to ensure that rights of those who are vulnerable, who are weak, or those who are discriminated upon, their rights are protected by using our skills. It is testing at times. Sometimes you will not be rewarded. Sometimes you will be pressured in a very bad way. But you must remember that the history of the world, if you look at it, it is always the lawyers who changed the course of the history, who made this world a better place. Be it our own Mahatma Gandhi, be it Nelson Mandela, and likes of him. There are so many people around the world. You will find examples. They were the lawyers. I would also mention something which is quite important, that there are different ways. I mean, I'm not very familiar with the fact how developed is the human rights law in India at the moment. If somebody asks my opinion, I would say that it should be well developed, because all the rights given in the Constitution of India, they point to one thing, and that one thing is each article gives a right to people or citizen of this country, which is they're all enshrined in the UN Convention. So all of those things are there. It's just whether it is developed in the right way or not. How do you implement these laws? You see, UK was signatory to UN Convention, UK was signatory to European Convention on Human Rights. But there has to be a legislation to ensure that those rights are implemented. The demand given in those conventions to which you are a signatory, you fulfill those obligations. And in order to ensure that the governments of the day or the authorities, they implement that law properly, or those rights given in these particular conventions, it is necessary to enshrine those within the domestic law, because these are the international law. And therefore, in year 2000, an act was incorporated in the United Kingdom. It was called the Human Rights Act 1998, which came into effect in the year 2000. If I'm not mistaken, it was October 2000. But this legislation, basically, what it did, it implemented that it was obligatory on the authorities that they must implement the convention, because there is a provision, any decision by a public body should not be incompatible with the UN Convention and the ECHR. I have worked with Mr. James Collins, who is a barrister. He is one of the leading barristers of the United Kingdom as far as human rights goes. And we have been working together since 1999. We all our important cases, Mr. Collins was involved, and he has been a great support to us, and he is a wonderful barrister, a lawyer, and a very compassionate human being. I would stop at this point because my colleague James will join you all soon, and you want to listen to what he has to say. Thank you so much. I welcome James. Thank you very much.
Thank you, sir. Thank you so much. Having a smooth life can't imagine the miserable condition of immigrants and how in 21st century many of us are still not get their basic human rights. We assure you on behalf of my college and students that they will follow path shown by you, sir. Thank you so much for your words of wisdom and spectacular speech. It will be a great pleasure for us to listen you again in future. Thank you, sir. Thank you so much.
You're welcome. Thank you so much for having me. Thank you.
Now, I would like to request the person who specializes in all aspects of public and administrative law with particular interest in immigration and human rights law. He has also represented number of applications to the European Courts of Human Rights in Strasbourg. In 2006, he was awarded by the Barrister of the Year and the Legal Aid Lawyer of the Year. So, ladies and gentlemen, we rarely get this kind of opportunity to listen to the words of great knowledgeable speaker, Mr. James Collins. Sir is here to imparting the knowledge on human rights. Sir, over to you.
Right. Thank you for those kind words. I hope you can see and hear me. The reception's a little bit up and down. I actually videotaped a piece yesterday, but we've had problems. So I'll be as brief as I can. The piece I videoed yesterday was perhaps too long. And one of the, can you see and hear me? Yep.
Yes, we can hear you, James.
Yes, sir. Yes, sir. We can hear you.
Okay, because it's just freezing, Sajid. But I'll carry on, and if anybody has any problems, if they raise a hand or let me know. So, human rights work. Well, human rights is a very broad term. The first thing one thinks of, it spans in immigration, obviously, nationality, extradition, and one thinks of freestanding human rights. But in fact, human rights and the 1950 Convention, the European Convention on Human Rights, impacts every area of law, even commercial law. What one thinks of libel, which prior to October 2000, as Mr. Sheikh has just highlighted, that's when the Human Rights Act 1998 came into force, 2nd of October 2000. Prior to that, a libel case would not have focused on Article 8 of the 1950 Convention. Now, most libel actions are about the competing interests of an individual, his right to privacy, often under Article 8 of the 1950 Convention, as against usually a newspaper or magazine, and the right to a free press. So I say that to flag up that human rights impacts on every area of law. The cornerstone of human rights internationally is the 1950 Convention. That was brought into effect actually in 1949, but we call it the 1950 Convention. It is persuasive around the world, even in countries that are not signed up to it. And when we get to, I'll take you quickly to the 1950 Convention, ECHR, you will see that the case law which flows from it is far too luminous to give more than a snippet of in relation to any of the articles. So the cases, I've sent a schedule over to Mr. Sheikh of some cases, some of which we've been involved in, him and I, but not for they're not the reason I refer to them. I refer to these cases, benchmark cases domestically as to the correct approach. And the cases I focus on in the attachment I sent over focus on one part only of Article 8 of the 1950 Convention, which is the of in the English courts, England and Wales. As you'll be aware, Scotland and Northern Ireland has a slightly different court system to England and Wales. The development in England and Wales as to the approach to families facing expulsion, particularly when children are involved. Now, any of the cases I've referred to, or any other English cases you hear of today, the best way of accessing them is Bailey, which is BAILLI, the British and Irish Legal Information Institute. That is free, and if you put in a neutral citation number, you should have access to the whole authority. As to Strasbourg, the court in Strasbourg, which is the European Court of Human Rights, generally referred to as ECTHR, that publishes a guide in respect of each of the articles, the protected articles. And the guide in relation to Article 8, the most recent one, is the 31st of August 2021. I've sent a copy of that over, and that runs to some 161 pages. And you'll see even from the index to that, how wide-ranging Article 8 is. We start with private life, privacy, physical, psychological, moral integrity, identity, autonomy, then obviously family life, home, housing, law firms, journalists' homes, prisoner correspondence, lawyers' correspondence. I flagged that up just to show how wide the ambit of Article 8 of the 1950 Convention is. Now, it seemed to me, when I was asked to do some introductory remarks about the 1950 Convention, the first question must be, well, what is the Convention? Well, the Convention is a international human rights treaty between the 47 states that make up the Council of Europe. That's not to be confused with the European Union. Governments that have signed up to the European Convention on Human Rights have thereby made a legal commitment to abide by certain standards of behavior. It is a treaty to prove law and promote democracy in countries. Having said that, it may come as a surprise to find that Russia is a member of the Council of Europe. It is presently suspended for obvious reasons, Ukraine and what's going on there, but Russia is still accountable to the court, which may seem somewhat incongruous given what is occurring in Ukraine, but it's worth highlighting that. As to how the European Convention on Human Rights was created, again, it's pertinent to observe that the idea for the creation of the convention, it was actually proposed during the course of the Second World War, while the war was still raging across Europe. Once the war had finished in 1945, in 1948 there was a Congress of Europe held in The Hague, a gathering of some 750 or so delegates, academics, leaders of civil society, major politicians, so Winston Churchill, Mitterrand in France, Konrad Adenauer from Germany. And from this gathering, ECHR began to take shape. And the beginning of it, the articles were actually imported directly from the United Nations Universal Declaration of Human Rights. So some of them were added too. It was formally drafted in 1949, came into being, to say the reason we call it the 1950 Convention, as against the 1951 Convention, which is the Refugee Convention, and the first signatory was actually the United Kingdom. In terms of enforcing ECHR, it's the Strasbourg Court which is responsible for that. Again, that should not be confused with the European Court, ECJ, or as it's properly called, CJEU, the Court of Justice of the European Union. That court, CJEU, is based in Luxembourg, and that has direct responsibility for European law. The Strasbourg Court has responsibility for human rights law. And prior to the Strasbourg Court being set up in 1959, it was time-consuming, expensive for people to say human rights have been infringed. And so that's the reason why the European Court was set up. Judgments of the court legally bind countries to stand by its rulings, and the resulting case law is often referred to as a living instrument as it develops. So unlike in, say, in England and Wales, and as I understand it, India and Commonwealth countries usually have a common law system, the doctrine in Strasbourg is not so much one of precedent. It's an organic approach to the law and to human rights. We're not looking at binding precedents. So the next question occurred to me, at least, was, well, how does ECHR relate to the Human Rights Act 1998 in the United Kingdom? And that act applies equally to England, Wales, Scotland and Northern Ireland. Now, the act, as Mr. Sheikh correctly said, came into force on the 2nd of October 2000. Pursuant to Section 6 of the Human Rights Act, it is unlawful for a public authority to act in a way which is incompatible with a convention right. That's every convention right. Now, that is written into primary legislation in the United Kingdom. Pursuant to Section 2.1 of the Human Rights Act, domestic courts are required to take into account Strasbourg case law. Now, on the run-up, the Human Rights Act coming into force, judges in the United Kingdom at all levels, from first-tier judges right the way up to then the House of Lords, received training on human rights, in-depth training. And what that meant was, by the time the Human Rights Act came into force in October 2000, they were, for want of a better description, generally tuned into human rights. And I think it's fair to say that the highest court in the land, the House of Lords, led from the front. At that time, I'm talking about October 2000 until about 2008, 2009, the constitution of the House of Lords in the United Kingdom, the Appellate Committee, properly called, contained some of the most outstanding and liberal jurists of the past century. So you will see mentioned throughout the major cases, Lord Bingham, S. Hale, who's just retired from the Supreme Court, Lord Hope, Lord Ross, Scottish judges, Lord Steyn, a South African judge, and from Northern Ireland, Lord Carswell and sadly deceased Lord Kerr. These judges were at one on how the Human Rights Act should impact on the way the United Kingdom approached an individual's rights. Unfortunately, not every level was so tuned in, so to speak, particularly lower immigration courts, which still adopted, I think it's fair to say, a restrictive approach, which led to challenges which Mr. Sheikh alluded to earlier, which practitioners such as him and I, of course, brought in order that the approach to the particular right challenged was a proper one. Now, in terms of ECHR itself, there are 18 articles. Some of them are absolute, such as Article 2, right to life, Article 3, prohibition of torture, cruel, inhuman and degrading treatment. Some are qualified. Article 8, as indeed is Article 9. Now, Article 9 is freedom of thought, conscience and religion. The lead case in the United Kingdom remains Ullah and Doe, ULLAH and Doe DO 2004 UKHL 26. That was a case, Sheikh & Co, Mr. Sheikh's previous firm was involved in. I actually wasn't involved in that case. Mr. Ullah was a Pakistani Ahmadi, and I think we all know the problems Ahmadi face worshipping in Pakistan, following their religion. Ms. Doe was a Vietnamese woman who feared persecution on the basis of her Roman Catholic faith in Vietnam. Now, if you care to read that judgment, you will see that the appellants succeeded on the principle, but failed on the facts. And that's something that one sees on a not irregular basis, that the highest court in the land, the House of Lords or the Supreme Court, will say, yes, your arguments are good, but on the facts, you can't necessarily succeed. And with respect to Ms. That's not perhaps surprising. I think it would be difficult to seriously say, certainly as of today, that a Roman Catholic would face persecution in Vietnam. But that's the main case in relation to Article 9. Article 12 is the right to marry and to start a family. So again, the lead case in this area is Baii, B-A-I-A-I. That's 2008 UKHL 53. And I flagged that up not because Sheikh & Co were involved in that, and I was, for what it's worth, but because a view may be that by 2008, we're 7 or 8 years after the Human Rights Act came into force in 2000, surely we would not need to go to the highest court in the United Kingdom to argue about Article 12. Well, we did, because in 2004, the government, and it was a Labour government, I don't wish to be political, But we can't put all the ills we face in this jurisdiction down to a right of centre government. It was brought in Section 19 of the 2004 Act. That's the Treatment of Claimants in Immigration Act, 2004, which made persons subject to immigration need to have to ask the Secretary of State, the British government, for permission to marry. Even on the face of it, that sounds odd. The reasons put forward by the government were frankly bizarre, and at each level, that's the High Court, Appeal, and finally the House of Lords, each court found that Section 19 was an arbitrary announcement. And for those reasons, we prevailed, we won. But I flag that up because it demonstrates that ECHR, being part of primary legislation, as part I showed you earlier, Section 6 of the 1998 Human Rights Act, is not a panacea. It's all well and good to have it in primary legislation. It needs to be implemented properly and not mere lip service paid to it. So the articles that I do, Article 8, it's worth reading out what that is. Everyone has the right to respect for his private and family life, his home and his correspondence. That's Article 8.1. 2, there shall be no interference by a public authority with the exercise of this right, except such as is in accordance with the law and is necessary in a democracy, in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, protection of health, morals, freedoms of others. What one sees from that, I suggest, is that Article 8 is the most open-ended, or at least one of the most open-ended, of the Convention rights. And the Strasbourg Court, rather than attempting to give a comprehensive definition of Article 8, adapts, as I've said, over time to meet changing times, to meet different cultures, different expectations. And Article 8, it's important to note, contains both negative and positive obligations. So the state is under a negative obligation, for example, not to interfere with privacy rights. But in addition, Strasbourg case law has extended Article 8 to impose a positive duty private parties for agreeing with an individual's rights. And you will see from Article 8, there are 4 express rights protected: private life, home, family, correspondence. You'll recollect from when I referred you to the Strasbourg Guide, just the index to it, how many sub aspects of those 4 there are. So correspondence, we've got a lot of the case law was about prisoners' correspondence, lawyers' correspondence, so on and so forth. So we see the protected interest, but the most effective claims, in my experience, have been made by individuals using Article 8 to overcome immigration controls when removal or deportation, particularly when children are involved. And when we get to argue Article 8 in that context, we're looking at what is in accordance with the law. We're looking at, is the impact of what the government says that they're allowed to do, is it necessary in a democratic society? And then crucially, the doctrine of proportionality is enshrined in European law. It is enshrined in Strasbourg case law. And much of the argument in courts at every level, from the first tier level up through upper tribunal, High Court, Court of Appeal, now the Supreme Court, It is about what is proportionate and what is disproportionate, and what margin of appreciation the United Kingdom, in our case, the United Kingdom government has. Now, in a case involving, for instance, terrorism, it's understandable that the government would say, well, the margin of appreciation is a wide one. It's a great one. We're looking at national security. And so in the United Kingdom, we have a court called SIAC, the Special Immigration Appeal. Sorry, it's just freezing there. Commission. And see and hear me. And SIAC often will not have open evidence, or some open evidence, much of it's closed. And it's understood that the state would say, well, we need a wider margin of appreciation. When we get to the rights of children, families and children in particular, I would suggest that the margin of appreciation much less. And that, as I say, leads to, has led to much of the argument at courts as to proportionality and margin of appreciation. Now, one of the attachments I've sent over, you'll see reference to a series of cases beginning with M. Croatia. I'll just explain these. I'll be as quick as I can. I'm looking. I appreciate that. And these cases underscore the point I tried to make earlier, that the European Convention and the fact it is imported into primary legislation via the Human Rights Act is not a panacea. Because M. Croatia, you'll see I say it's a starred decision of the tribunal. Now, by starred decision means that the point of law is binding on lesser courts, which is the first tier tribunal now. So back in 2004, this would have been the second stage up, the IAT. A High Court judge was the president. And you will see from even this one paragraph I've inserted from M. Croatia that notwithstanding ECHR is now part of the primary legislation, the panel say, first of all, it would have to be a truly exceptional case to succeed. And in terms of proportionality, any challenge to the Secretary of State, the government's view, has to be on what we call Wednesbury grounds, about reasonableness and rationality, which is a very high threshold. And you'll see what they said. We cannot think of one at present. It's not been ruled out. So that set the bar so high that the Court of Appeal, I mean, basically, you were doomed to fail on a proportion as a result of M. Croatia, which led the Court of Appeal to bring in 9 or 10 cases, sift through them, and decide to pick 3 as test cases on the M. Croatia point. And the 3 cases were Hwang, Kashmiri, and Abu Kulbain. And again, for what it's worth, Mr. Sheikh and I were involved in the Abu Kulbain case. And you'll see how the Court of Appeal approached M. Croatia. They agreed with us in our in principle arguments that at the first tier, the primary finder of fact, in those days an adjudicator, now the first tier tribunal, it's not a Wednesbury review, it's not a public law review. It's a merits review looking at all the evidence at date of hearing. So they agreed with us. But they went on to force what the tribunal in M. Croatia has said about the exceptional case is the only one that could win. And on that basis, dismissed the appeals of Kashmiri and Abu Kulbain, but allowed the appeal of Mrs. Hwang. The Secretary of State appealed Hwang. Kashmiri appealed to the House of Lords. Unfortunately, from our position, Sheikh and Co and myself, Abu Bain didn't want to appeal. So we played no part in Hwang in the House of Lords. But when we get, and I would urge you to read Hwang, it's a benchmark case, not just in the United Kingdom, throughout the world. not just the common law countries. And I've emphasized, I think it's fair to say that the House of Lords in Huang were bewildered at what the tribunal in Croatia had said and how they approached proportionality. I think they were equally bewildered and certainly to a degree angry
Thank you, sir. Thank you so much, sir. Truly said by sir, just like the UK and especially in Strasbourg court, it is necessary for every country to enforce UNCHR as a basic primary legislation. Then only we will protect human rights in true sense. Thank you, sir. Thank you so much. It will surely help us to understand the aspect of human rights. Thank you for sharing your bundle of knowledge with us. Thanks a lot. Now, it's a time to give a chance to our multitasking co-chairperson who is working with as associate professor in law. The Maharaja Sayaji Rao University, Baroda. Dr. Archana Gadekar ma'am, who is belonging to the home state of Mahatma Gandhi, the father of nation. She is chairman of Board of Studies and former Senate member of Maharaja Sayaji Rao University, Baroda. She is a member of Research Advisory Committee of a different university. I would like to call Dr. Archana Gadekar ma'am.
Thank you, Radhika.
Welcome, ma'am.
Yeah. So it's a pleasure being here. And first of all, I extend my thanks to Dr. Varsha and her entire team for giving me an opportunity to interact with you all. This technical session 3 of this 2-day international conference, I found it to be very informative and very interesting. To begin with, as it was that we began with 3 learned resource persons, and each of them, they shared their knowledge with us, they shared their experiences with us. So to begin with, Dr. Rajendra, he talked about sustainable development, then he talked about the protection of environment and also the rise of environment jurisprudence, wherein he, while tracing this, he traced and discussed several cases of the Honorable Supreme Court of India. And the second resource person whom we had, it was Mr. Sajid Sheikh, who is an alumnus of the P.D.C.L. He also shared his experiences, how it was working in the United Kingdoms, how it was his experience during the initial years, then how he came across the human rights cases, and then he discussed and focused upon the newer trends in the human rights. Now, while this, he discussed the experience in the as it is in England. Then after that, we had James Collins, who also introduced us to a different area, I should say, wherein he discussed the International Human Rights Treaty, which was adopted by Europe and which was especially to guard the fundamental freedoms and human rights in Europe. And also, very importantly, he discussed the various facets and dimensions of right to privacy. Now, along with this, if I just would like to sum up the various papers which were received for this human rights. So I like to tell everyone that it was like for this particular session, almost 10 to 12 papers were received. Overall, it was around 60 papers is what I have been told by the organizers. So now here, this 10 papers which we had, now they focused on various broad dimensions, if you can say. Like if I found them to be on various aspects like human rights, health and law, then women empowerment and human rights, then on human trafficking, then on environment protection, and also very importantly, the interface between law, science and technology. Now, I'll focus upon the last one a little bit later, but before that, I'd just like to take you all through the conclusions which were derived upon by the various authors in their papers. Like if we talk about the environment protection, we had one paper on noise pollution, wherein the author has called for a stringent punishment for noise pollution. Then another paper which was like, if you say health and law and human rights, so that was on leprosy, wherein the author has specifically voiced for elimination of discrimination against the leprosy affected persons. Then one paper on human rights, and that speaks of that there is a need to change the societal outlook for the implementation of the of all the legal provisions. Now, next we have a paper on human trafficking, wherein the author views it as one of the emerging crimes of organized crimes in the society. And interestingly, looking to the newer developments which we are having as far as the decriminalization of Section 377 is concerned, and what is its impact on human rights, a paper has been submitted or presented, I should say, wherein the author has suggested that there is a need for amendment in the personal laws. Now, as I said, that we are having one of the areas of interface between law, science, and technology and human rights. So here, there are around 2 to 3 papers which are talking about data privacy, and they're talking about cyber defamation. Now here, when we are talking of cyber defamation, the author has drawn a comparative study with the provisions of the United Kingdom, USA, and Australia, and this has been done primarily with the liability, with respect to the liability of the primary publisher of the defamatory material. What is the position in different parts of the in these 3 different countries, and what is the position in India? That is what the author has tried to see. Then we are having 2 papers on data privacy. Now, here it's very interesting to note that these 2 papers, one paper is calling for striking a balance and understanding that the data protection is not an absolute right. So a balance has to be made between right to privacy and the data protection. And secondly, there is another paper wherein the second author has argued for amendment in the Right to Information Act regarding data protection, and has also argued that protection of data is a human right and fundamental right, and there is need to spread awareness about this. Now, I will go forward with this last paper, which is saying that the author has actually declared that this is a human right, that is, protection of data is a human right. So like here, I'll just take 2 minutes wherein I'll try to trace the development of the various generation of human rights. Because whenever we talk of human rights, we are talking about the generation of human rights. So as we all know that long ago when we had the first generation, that was talking of the civil and political rights. The second generation was talking about the social, economic, and cultural rights. And the third generation is mainly encompassing over the idea of the right of self-determination, wherein we mostly talk about this healthy environment and the things like that. Now, like right now, we are in the 4th revolution, and this 4th revolution, is actually disrupting the economies, business models, and the societies around the globe. So now here, what happens is that what we need to understand is what about the human rights concepts and the practices. So because of this, that we are facing problems, not only, these are not like international problems or global problems. This is a problem because nowadays we are into the global village. So now here we are posed with a question that are we on the cusp of a new human rights revolution? One driven by technology, climate change, and social development. And thereby, one important question that comes to our mind is that now is it high time to say that there is a need to declare a 4th generation of human rights, namely like access to internet, digital technology, or rights in the digital world. Because, with the development of the technology, what is happening is that these newer rights, we are nowadays discussing about right to be forgotten. We are talking of artificial intelligence. Then its interface with the right to privacy. So all these rights, they are now bringing us to discuss and decide that is it high time that is it a high time to declare that there is a fourth generation of human rights, wherein we will be having the rights in the digital world as our basic human rights. So with this question, I leave this question open for the House to ponder upon. Thank you. Thank you so much for inviting me.
Thank you, ma'am. Thank you for evaluating the research paper submitted by the researchers for this international conference and guiding our emerging research scholar. Thank you for your inspiring words, which would always enshrine in our heart. We promise to put your words into the practice. Thank you, ma'am. Thank you so much. Now, the moments have come to add a golden feather in the heart of success. I'm going to invite such an outstanding personality who is well equipped with a technical and communication skill. Our chairperson, Dr. Smita Deshmukh, Principal Matoshri Vimlabai Deshmukh, Mahavidyalay, Amravati. Ma'am is a ex-dean and Senate member of Academic Council, Sant Gadge Baba Amravati University, Amravati. She is a executive member of NAC, expert committee member of UGC, and working with many other universities in India. Ma'am is a personality who has counseled herself to change the academic approach and light the darkness in the life of student. I request Dr. Smita Deshmukh ma'am to deliver the chairman speech. Over to you, ma'am.
Thank you so much, Rasika ma'am.
Radhika.
Radhika. समय इंसान को सफल नहीं बनाता, समय का सही इस्तेमाल इंसान को सफल बनाता है. Today, on this occasion, just on the Punjab Rao Deshmukh College of Law, Amravati is conducting 2 days multidisciplinary online international conference. And I think after day by day, just we are grooming so highly because we all aware of the program with the Bhushanji Gawai also, and these emerging issues and the challenges in human rights, commercial laws, women empowerment in contemporary global society under the guidance of our patron, Dr. Harshavardhanji Deshmukh, and very eligible, very vibrant personality, my friend, Dr. Varsha Deshmukh. Today, just we are very eagerly listening to Indian resource person, Advocate Rajendra Ambule sir. He was Supreme Court, India, New Delhi, and reflected his thoughts on human rights, environment, and again, everything about the right. Then the international resource person, Mr. Sajid Sheikh, MD, Central the Solicitor, United Kingdom, and Mr. James Collins, Barrister 36, Bedford Row Chambers, focused on Article 19 also, and co-chairman very easily just interpreted on the various papers, and Associate Professor Sayajji Gaikwad, Archana Gadekar ma'am, Baroda University. So at the outset, Radhika and Varsha ma'am, just I want to congratulate you for this, for the whole conference also. And in this third technical session, I am thankful to organizer and this wonderful, informative and very innovative ideas, and in such a way you grabbed Asma Muthi mein. That means whole world is now gathered in law college, I think so. So after these resourceful speeches, I want to say that I hope that the participant will strive hard to protect the human rights. When we are talking about the evaluation of human rights, the preamble of Indian Constitution reflects the inspiring words with a specific mention of dignity of the individual. मराठी मध्ये त्याला प्रतिष्ठेसह विकास असं आपण म्हणूया. Though we are global, we are well acknowledged with our Rashtrabhasha Hindi, our mother tongue Marathi also. The Constitution, the epitomize the ideals, aspirations, the sentiments, the ideas, and the precepts and the goal of our entire freedom movement. The wisdom of the forefathers of our constitution was justified in incorporating non-justiciable human rights in the concrete shape of directive principles. And so, human rights based on the principle of respect for the individual. Tomorrow we'll celebrate the Women's Day. And so on this occasion, just I want to say the happy Women's Day to one and all also, because right to live, right to do, right to express, right to get married, Saji said already said on that, each person deserved the respect, each person deserved treated with dignity. They are called as human rights and they are universal, whether we belong to India or United Kingdom or Russia, anywhere. The human rights are indeed to protect and preserve our individual's humanity, to ensure that every individual can live a life with dignity of life that is worthy of the human being with the birth till death. So the human resource or human right are standards that recognize the protect the dignity of every human being, right from it covers all the caste, creed, religion, countries, everything. So it governs how individual human beings live in society and with each other, as well as their relationship with the state and obligations that state have towards them. So it is something to which you are entitled by virtue of being a human. Human rights are the set of principles concerned with equality and fairness. And these are the points I've taken from all the speeches I have we have already gathered here. And so the human rights idea into the practice can help us to create such type of society we want to live in. So at last, I want to conclude all those things, that right to education, freedom of press, role of media, everything just we have explained in very detail, that right to life, right to live, right to be happiness, right to education, everything. So it would not be wrong to say that the violation of human rights can be controlled only when there is a firm determination for human dignity and values. It is equally important that the Indian society at large should have proper approach and attitude towards the protection of human rights. I think Varsha ma'am has written a very nice book on human rights also. I congratulate for that also. I have certain suggestion for the protection of human rights. I think maybe incorporated, but I came to know the education related to human rights must be included as a part of curriculum. Though it is part of law, it is not part of law. Just I'm working as an academic counselor, I'm working as a dean, I worked as a dean, I'm working as a senator also. Why should be a part? So the multidisciplinary approach should be there, so that in NAP 2020 it is written that multi-entry, multi-exit, I think we can enter as such. We should, each and every student should know about the human right. And so the research in the field of human rights should be should be strengthened. So while concluding, I say that these rights belong to you. They are your rights, and therefore you must be familiar with them. You must help to promote and defend them for yourself as well as your fellow human beings. And so at last, I said once again that पहचान बड़े लोगों के साथ नहीं, साथ देने वाले लोगों के साथ होनी चाहिए. I think today just we have just well connected and well versed with all these dignitaries in this session, the three-four say in these sessions, and I think this will be definitely in future the coordination, क्योंकि आज जो सफर की शुरुआत करते हैं वे मंजिल भी पा लेते हैं. बस एक बार चलने का हौसला रखना जरूरी है, क्योंकि अच्छे इंसान के रास्ते भी इंतजार करते हैं. So I wish again all the best and success to this conference, and thanks for giving me opportunity. Namaste. Thank you. Thanks a lot. Have a nice day.
Thank you so much, ma'am. Even I feel that thank you is a very small word for you. I am uttering. Your speech has full of passion and is priceless. I assure that we should follow your footsteps to reach these stars. Thank you, ma'am. Thanks once again.
Let me share one thing. Madam has been selected, shortlisted for the Vice Chancellor's post in the middle of Maharashtra, middle coast.
Many congratulations to you, ma'am.
Thank you. Thank you so much. Thank you so much. Thank you, Sajid. Thank you, Colleen, and thank you, ma'am.
Yes. At last, I would like to say, life doesn't require that we be the best. Only that we try our best. Without further delay, now I would like to call upon Professor Mahendra Ingole sir to deliver the vote of thanks. Over to you, sir.
Thank you, Dr. Radhika Deshmukh. Good afternoon, good evening, everyone here in India. I deem it a great honor and privilege rendered to me by my honorable principal, Dr. Varsha Deshmukh, to propose the vote of thanks on this intellectual discourse of 2 days international multidisciplinary online international conference on emerging issues and challenges on human rights, commercial law, women empowerment in contemporary global society. So we are concluding this technical session 3 on human rights of day 2 of the international conference. Friends, let me first of all start by offering my obeisances to Dr. Panjabrao Bhausaheb Deshmukh, the founder president of Sri Shivaji Education Society, Amravati, who provided us this platform for intellectual discourse. Friends, saying thank you is more than good manners. It is good spirituality. Let me first of all thank our esteemed international resource person, Mr. Sajid Sheikh, MD, Sentinel Solitaires, United Kingdom. I also extend my sincere, heartfelt gratitude to second international resource persons of our technical session, today's technical session, Mr. James Collins, barrister, 36 Bedford Row Chambers. Friends, I also extend my heartfelt gratitude and thanks to Indian resource person, Advocate Rajendra Anbhule, Senior Counsel, High Court, Bombay Bench. I again express my gratitude to the chairperson of today's technical session on human rights, Dr. Smita Deshmukh, Principal, Matoshri Vimlabai Deshmukh Mahavidyalaya, Amravati. I also extend my heartfelt gratitude and thanks to co-chairperson of today's technical session, Dr. Archana Gadekar, Associate Professor, the Maharaja Sayaji Rao University of Vadodara, Gujarat. Thank you. Sincere thanks also are extended to the staff of Dr. Panjabrao Deshmukh College of Law, Amravati, 3 years course, 5 years course, and PG course, and also to staff of Sentinel Solicitors, United Kingdom, who handled the event throughout. A wide round of applause and thanks to all the participants who made this event a memorable one. Finally, friends, I would like to thank all of you present here for making the time to be with us today and helping us make this event a grand success. I also thank the G-Gate Index Research Nebula, an international refereed peer-reviewed and indexed quarterly journal in arts, commerce, education, and social sciences for getting our publications published and papers published. Thank you once again. Thank you one and all. Over to you, Dr. Manish Wadive, for valedictory session.
Thank you, sir. A very good evening to one and all. It gives me immense pleasure to note that this international conference was organized in a very professional manner within a very short span of time, of course, with well preparation. And now it has come to its culmination with the valedictory session. To grace this occasion, we have the eminent luminaries and resource persons who will spare their valuable time, precious insights, and expertise with the participants. It is an honor to have with us our chief guest for the day, Honorable Advocate Gajanan Punkar sir, Vice President, Shri Shivaji Education Society, Amravati. On behalf of the organizers and participants, I, Dr. Manish Wadive, extend a warm welcome to sir. I also welcome our guest of honor, Honorable Dr. Vijay Kumar Chaube sir, Dean, Faculty of Humanities, Sant Gadge Baba Amravati University, Amravati. He is head of postgraduate teaching, Department of Law, SGBAU Amravati. Thank you for your gracious presence for this valedictory session, sir. I also welcome our respected principal, Dr. Varsha Deshmukh ma'am. She has been a strong pillar of support for all of us. She inspires us to move forward no matter what. I also welcome all our esteemed participants, teaching and non-teaching staff, and dear students to this valedictory session. I will now deliver a short report of the conference. This two-day conference, international conference on emerging issues and challenges in human rights, commercial law, and women empowerment in contemporary global society was organized by Dr. Panjabrao Deshmukh College of Law, Amravati, in collaboration with Sentinel Solicitors, UK. The 2 days conference commenced on 5th March 2022 and is concluding today on 6th March 2022. It was attended by around 250 participants from India and abroad. For the inaugural session on 5th March 2022, it was the duty vested on Dr. Prachi Parag Kadu to welcome the guest and conduction of the program. In the inaugural address delivered by the inaugurator, Honorable Advocate Yashomati Thakur, Cabinet Minister, Women and Child Welfare Department, focused on earnest need for women empowerment and human rights. In the presidential address, Honorable Shri Harshavardhan Deshmukh, President Shri Shivaji Education Society, emphasized that great institutions are not built overnight. It is the pioneering vision of Shikshan Maharshi Dr. Panjabrao Deshmukh translated into reality by the incessant efforts of administrators, principals, teaching and non-teaching staff. Guest of honor, Advocate Jayant Jaybhave, Member Bar Council of India, appreciated the efforts of taking conference on this challengeable topic. And Dr. Vijay Kumar Chaube sir, Dean Faculties of Humanities, gave insightful remarks. In the welcome address, organizer and principal, Dr. Varsha Deshmukh ma'am, focused on the paramount importance of human rights, women empowerment, and commercial law. Co-organizers, Mr. Sajid Sheikh, MD, Sentinel Solicitors UK, Dr. Dilip Uke sir, VC, MNLU Mumbai, also graced this occasion. And the vote of thanks was given by the convener of this conference, Dr. Nanda Kishore Ramteke sir. Moving next, on day 1, 5th March, technical session 1 on commercial law was handled by CA Anupama Ladha. In this session, the international speaker, Honorable Elena Mangasirian, Columbia University, spoke on current trends and regulations regarding cryptocurrency and digital assets, followed by a detailed analysis of the competition law and its various aspects by Honorable Vikram Sopti of Chandiok and Mahajan Law Firm, New Delhi. The session was summed up by the chairperson, Dr. D.S. Dhote, Principal, Brijlal Biani Science College, Amravati. Apart from this, co-chairperson, Dr. Shaista Inamdar, Principal, Navjivan Law College, Nashik, presented a detailed analysis of the various research papers presented by the participants. The session ended with the vote of thanks presented by Dr. Prakash Dabhade, co-convener of this international conference. Day 2, technical session 2 on women empowerment was led by Professor Aditi Thakre. International resource person, Honorable Tatiana Niviva, co-headed the international conference. She is the co-head of the international arbitration at EPAM, Russia. She delivered on women's contribution in arbitration. Followed by Dr. Sharmila Guge, JC College of Law, Mumbai, stated that need for overall empowerment of women's economically, socially, and emotionally too. Dr. Shashikala Gurupur, Director, Symbiosis Law School, urged for creation of equal society through empowering women. Chairperson, Dr. Asmita Vaidya ma'am, Principal, Government College of Law, sum up the speakers wonderfully. Co-chairperson, Dr. Anjali Thakre, Principal, Shivaji College of Physical Education, Amravati, presented a detailed analysis of the various research papers presented by the participants. The session ended with the vote of thanks proposed by Professor Mahendra Ingole sir, who is also the co-convener of this international conference. Day 2, technical session 3 on human rights was conducted by Dr. Radhika Sachin Deshmukh. International resource person, Mr. Sajid Sheikh, shared his experience in human rights, followed by James Collins, barrister, 36 Bedford Row, Chambers, acquainted us with versatile knowledge on human rights. Advocate Rajendra Anbhule, AQR, Supreme Court of India, New Delhi, and enlightened us on clean, healthy, sustainable environment as a universal human right. Co-chairperson, Dr. Archana Gadekar, Associate Professor Sayaji Gaikwad, Baroda University, Vadodara, nicely sum up the research articles. Chairperson, Dr. Smita Deshmukh, Principal, Matoshri Vimlabai Deshmukh Mahavidyalaya Amravati, gave insightful remarks. As a part of international conference, at the end of the technical session, the participants were requested to fill a brief feedback form of 2 days conference and submit it as an assignment for evaluation process. Certificates will be issued soon after assessment and review of all participants. In the conference, all participants participated enthusiastically in the question and answer session. In short, this international conference sought to provide a creative and supportive environment in which ideas were generated through interactive sessions with eminent speakers and leading researchers. I would like to call here, or we would like to hear from the guiding light of this conference, the chief guest of this program, Advocate Gajanan Punkar sir. He is the Vice President of Sri Shivaji Education Society. I feel very honored and glad to inform you that sir has completed his LLB from our Punjab Deshmukh College of Law, and he is our alumnus. Sir is also the Vice President of Sri Shivaji Education Society. He is also the Vice President of Maharashtra Rajya Police Patil Association, Maharashtra. He is also the Director of New Narnara Seeds Corporation, Asegaon Bazar, Taluka, Akot. Respected sir, I welcome you. It is over to you, sir. Please guide us on this occasion. Respected Gajanan Punkar sir, please guide us, sir.
Is sir online? I think he was online just few minutes before. Sir was online.
Hello.
Yes,
sir.
Sir
Yes,
is
sir.
there. Yes, yes.
Yes, sir.
Yes, yes, yes.
Yes, sir. Yes. Thank you, sir.
Warm greeting. It is my immense pleasure to welcome you all the first online multidisciplinary international conference on emerging global issues and challenge on commercial law, women empowerment, human rights in global contemporary society on 5th and 6th March 2022, organized by Sri Shivaji Education Society, Dr. Panjabra Deshmukh College of Law. I pay my esteemed regards and respect to the great visionary and educationalist, late Bhausaheb Allies, Dr. Panjabra Deshmukh, founder president of this esteemed Sri Shivaji Education Society. I am extremely honored to introduce our guests for this multidisciplinary online international conference. A man of integrity and vision, none other than Honorable Sri Harshvardhan P. Deshmukh, President of Sri Shivaji Education Society and President of this conference. The inaugurator of the conference is Advocate Yashomati Thakur, Cabinet Minister and Minister for Women and Child Welfare, Government of Maharashtra. She is also Guardian Minister of Amravati. She is very dynamic personality. Pattern Honorable Dilip Ingole, Treasurer of Sri Shivaji Education Society, Mr. Sajid Sheikh, MD, Sensational Solicitor, United Kingdom, who is joint organizer of this international conference. Many eminent personalities from across the globe will participate in this conference to share their views and thoughts, like Elena Maganazam, International Legal Council, Legal Tea Specialist, Columbia University, Tatiana Nevia, co-head of International Arbitration at EPAM Russia. Mr. James Collins, Barrister 36 Bedford Row Chambers, Professor Dilip Uike, Vice Chancellor of Maharashtra National Law University, Mumbai, Dr. Shashikala Gurpur Director, Symbiosis Law School, Pune. Mr. Vikram Sopti, partner in law firm Chodio and Mahajan, New Delhi. Dr. Asmita Vaidya, Principal, Government Law College, Mumbai. Advocate Rajendra Anbule, AOR, Supreme Court of India, New Delhi. Advocate Jayan Dattatre, Jaivae, Member, Bar Council of India. Dr. Archana Gadekar, Associate Professor, the Maharaja Sayajirao University of Baroda at Vadodara. Dr. D.S. Dote, he is my friend, Principal, Brijlal Biharni College of Amravati. Dr. Smita Deshmukh, Principal, Matosri Vimlabai Deshmukh, Mahavidyalay, Amravati. Dr. Shahista Inamdar, Official Principal, Naujivan Law College, Nasik. Dr. Anjali P. Thakre, Principal, Sri Shivaji College of Physical Education, Amravati. Dr. Vijay Kumar Chaube, Dean, Faculty of Humanities, Head of the Department, PGTD of Law, Santa Gadge Baba University, Amravati. The active participation of all these resource persons will certainly create an atmosphere for the brainstorming in areas of different subject of this conference. The conference theme is emerging global issue and challenges on commercial law, women empowerment, human rights in global contemporary society. The first theme, commercial law, which guides and regulates all commercial transaction activities and relationship exciting between and among all business entities. Regulatory authorities, business supporting agencies, means of transportation and consumer. Thus, commercial law is paramount importance for smooth, fair, and profitable conduct of business in various sector of commerce and economy. Also known as business law, the commercial law is considered to be a part of civil law, which includes the matters and issues of both private law and public law. Global juris essentially offers an extensive and exclusive range of legal services for this vital and magnificent field of law and in general. The second theme is women empowerment can be defined to promoting women's sense of self-worth, their ability to determine their own choices and their right to influence social changes for themselves and others. It is closely aligned with female empowerment, a fundamental human right that's also key to achieving a more peaceful, prosperous world. In Western countries, female empowerment is often associated with specific phases of women's rights movement in the history. This movement tends to be split into three views. The first beginning in the 19th and early 20th century where suffrage was key feature. The second wave of the 1960s included the sexual revolution of the and the role of women in society. Third wave, feminism, is the often seen is beginning in 1990s. Women's empowerment and promoting women's rights have emerged as a part of major global movement and is continuing to break new ground in recent years. Days like International Women's Empowerment Day are also gaining momentum. But despite a great deal of progress, women and girls continue to face discrimination and violence in every part of the world. The third theme, human rights are the basic rights and freedom that belong to all people in the world from birth to death. These rights are based on shared value like dignity, equality, fairness, respect, and independence. These ethics are protected and defined by the law of various countries. Some human rights are more visible than others. It's much easier for people to relate to rights like the right to vote or the right to fair trial in court of law. These are often related to the roles of government and the democratic process. But some human rights are more fundamental and often unknown to the public. For example, the right to health is one of the most important yet overlooked. Without health care, people can't fulfill their basic needs like getting a good night's sleep or not getting sick. They also can't contribute to their communities and may even die from preventable diseases. You can think of human rights as the right to a basic, adequate standard of living as a protected by human rights law. If you think your right have been violated, this conference will certainly provide a great platform to academicians, research, and professionals to exchange their research result and development activities through research paper published in online international referred peer-reviewed index journal with impact factor 7.399 research nebula journals. I am very grateful to the convener, co-conveners, entire core team who work day and night for this prestigious conference. I also thank all the participants who have wholehearted, generous response to our invitation. I wish the conference grand success. Thank you, all of you.
Thank you, sir, for your valuable observation and inspiring address. We are greatly indebted to you, sir. Thank you very much, sir. Thank you.
Okay.
I now call today's guest of honor, Dr. Vijay Kumar Chaube, sir. It is indeed a privilege to hear from dynamic professor, Dr. Vijay Kumar Chaube, sir. He is stalwart in the field of law. Dr. Vijay Kumar Shri Krishna Chaube, sir, is the head of PGDT department of Sant Gadge Baba Amravati University. He has around 20 years of full-time teaching experience, including work experience at national and international level. He has been Dean of Law Faculty. He has been ex-member of Management Council. He has been the member of BOS and Faculty of Law at Amravati. He has been the chairman, Faculty of Law members. He has been the chairman of Studies of Law, SGPAU. He was member of BAOS, North Maharashtra University, Jalgaon, head Central Administrative Service Unit, SGPAU, Amravati. He is the chairman, research advisor committee at Research Center, Department of Law, SGPAU, Amravati. He is the recognized supervisor for Faculty of Law at different universities. And he has around 11 books, 17 international articles and 35 national articles has been published till now. And he has also attended conference at Greece, Italy, Thailand, Sri Lanka, Bhutan, Switzerland, Cape Town, and South Africa. Sir is a well-known personality in the field of law, and is having a vast experience in research field also. He is having a major role in conducting various prestigious examinations like UGC NET, GRF. He has conducted all these examinations in university, PET examination he has conducted, and it is a long list of achievements. He has a long list of achievements, but I will sum up here and invite sir to grace this occasion, and I will invite sir to host the audience, and the platform is yours, sir. Please, sir.
Am I audible?
Yes, sir. Yes, sir.
Am I audible?
Yes, sir.
Yes, sir.
Okay.
Yes, sir.
Thank you, Manish ji, for kind words, but I think that it is a repetitive one because yesterday itself I had been there to witness this good conference going on these very vital issues. Really, the earlier speaker and the vice president of this great society, Punkarji, has read the entire things. about this 2 days national international multidisciplinary conference that has been organized under the aegis of the active principal of your college, Dr. Varsha Didi. All the participants, those who are the resource person across the world, across the globe, and academician, researcher, students, and my budding lawyers. At the very point where we are going to say goodbye to this very good gathering on such a very good platform, that emerging global issues and challenges on commercial law, women empowerment, human right in global contemporary society. A few words and few things is required to be have the great cautions we need to deliberate. I think that this up to 3 technical sessions, several things has already been deliberated, and the chairman would have also been compiled, and they would have also narrated the entire report one. Few things just I wanted to add it within a few minutes, a couple of minutes I will take, and I will just wanted to have one few things that is required to be deliberated on these good issues. First thing is that just I feel that from the very historical evolution and historical development, we have witnessed the state as a major institution, political institution to decide the fate of their citizens. We had seen that there is so many geographical areas the state has formed, they transformed, one by other, invaded, invasion has been taken place, swallowed by some other superpowers and all those things until last millennium. We have seen that almost all the geographical boundaries of most of the nation has already been set up. And then the state has on the march to have the welfare state, who also fortunate to have its constitution, where the state has taken this obligation to have the welfare nature of its own, to give some social economic policy to be get fulfilled as an responsibility. We have seen across the globe, there are so many states, they have taken this responsibility to fight for the welfare of their populations. And so many issues are there, but the development till last 70 years is really, I can say that much more satisfactory so far as the role of a state is concerned. Again, we have seen that the human right philosophy that was officially emerged in the mid of the last millennium was also given some different role to the state. We have deliberated in this so many things about the human right, that we are entitled all those list of the human right, but because being human. The issue is that is also remain to be deliberated, that what we deserve of being human and what exactly we assign the things to be human. The barbaric that the human possesses within its accumulating so many resources and exploiting the other, whether that can be assigned the good quality of being human, and whether such person is really entitled for being a human right, they entitled for that. That is another part. I will just focus on only one very important issue, that in these days when we are discussing about the emerging global issues and challenges, I feel that the role of the state that has been greatly these 17 years, we can just see that, take for example, so many examples we can just see that, take for example India, take for example our neighboring countries and superpower, their role has been a little bit modified. From the state of the sovereign, they have become the dominating partners in the economic field. Then they have again become the facilitator to carry out so many commercial taking part, they enter into the mixed economy, and then under this particular way of the privatization, they have become the regulator, and they are just the new spectator of what is going on under the commercial activities of the state. So many multinational companies, they are entering to the commercial field and really giving the meaningful things to the economic regulations across the globe. Economic regulation to so many policies, they are influencing the policies of the emerging third world country and all those things. I think that we must have to assign certain value-based the instinct to all this development. Nowadays, the commercial development is at its peak. So many industries are to health, but try to understand that after educating so much things, our health issues are really at a great state of affair, that we are having the adulterated food. The food that we consume is not much more of good quality. The junk food is containing so many things, and that has been done by the multinational companies. That has not been done by the milkman who is bringing the milk at our doorstep. So many packed food, so many things that has been bringing by all these multinational companies are really nothing but the violation of our human rights. Whatever they are doing under the grab of development and all those things is really, I feel that needs certain value culture, so that they have to understand that whatever they are doing under the commercialization or whatever they are adopting the policies are really the destructing the entire human population. In any field, take for example, we had already witnessed this pandemic. During this pandemic, what are the role of the state that has been played, and what are the role of, if we can take the news seriously, that this was the man-made virus that is spreading as a corona. If this is the news is true, we have to again rethink about our developmental phase and our scientific development that is very destructive for the human being. And again think that what are the role we are playing for the forthcoming generation. In fact, I am very firm believer that this particular environmental resources, what we are possessing, is not what we have inherited from our forefather, but rather it has been the loan that we have taken from our forthcoming generation, and we have to give them back the good environment, good earth, good and well resources and meaningful things that they can have their well life. So we are just holding this entire things in our hand as we are the debtor. We are just the person who are holding this as a trustee, and we have to hand over all these things. So the first thing is that the state, which was earlier supposed to be the great violator of human right, and in last 70 or 80 days turned to be the great protector of human right, now is on the back seat, and multinational companies and great commercial partners are dominating the policies of the government and setting the new normative pattern for all these economic scenario, and playing their role, keeping the profit before their eyesight, and they are just earning a lot that we have just witnessed. Sir has really used the word right to health. We have to understand that who is holding the responsibility to maintain the health of the society. It is the state, but you can just see that the private hospitals, private enterprises, they are just taking up and they are just extracting a lot of money, considering this is an opportunity. So many things we can just think that the change in the role of the state, which is now only become the more spectator as a tax collector and merely the regulator, and not checking the all these things, rather bending down before these multinational companies who are engaged into the commercial practices, commercial transactions across the globe. Now we again have to think that what we, being a human being or being a population, being the civilized person, can assign the rule, assign the values so far as the humanity is concerned. If this we can think, then only we can have the great future, then only we can ensure our civilization. And if it is not overdue, I think that we are already too late, particularly in the area environment and all those things. So this is the very end point where already so many things has been deliberated, and already so many participants has expressed their views. The chairpersons, the resource persons has contributed well. Only the cautious things is that I just wanted to say that the great challenges is in the approaches and the interpretation that we have. It is not other than the things that what we are, it is the what we interpret and what our approaches provoke us to become. If we think that this is the globe where we are only the consumer and we can consume everything and do not let our forthcoming generation to have their share into this great earth, then we do not ensure the future of this society, neither our state, nor our society, nor our forthcoming generation. But if we think that we are merely the trustee at this stage and we have to hand over this great green earth to our forthcoming generation with good and value-based society where human being and not only human being, now we need to again have the another point to be added in this, that animal, how we treat that animals. And you can just see while walking on the footpath, walking on the as a pedestrian, you can see that how we treat the animals and all those things. The entire flora and fauna of this earth is required to be protected, because now being human, if we need to have the human right, we must say that we are the human being. Only then we can deserve the human right. So many things have been already deliberated. I feel that there are so many things this conference has given embedded into the fertile brain of this budding can have to discuss all those things during their curriculum, during their discussion with other friends and all those things. I think that this 2 days multidisciplinary international conference has given its own way. And I think that it has initiated a good talks among those who have participated. And it would be the initial deliberation point for in day to come, when into the corridor of Punjab Rao Deshmukh Law College, these things will echo, that whatever has been deliberated in 2 days seminar, what has been discussed by the participants will definitely whirl into the particular corridors and into the building of your law college. And out of that, it will definitely come into the society, and it will definitely have a great transformation in day to come. Thank you very much to P.D.C.L College as well as the Sri Shivaji Education Society, who has definitely contributed well academically, and as well as their energies are now become vibrated from their buildings to the minds of the people, and whatever they are having the good, we can say that heritage now with the help that first this we can say this Babu Sahib Punjab Rao Deshmukh ji, whatever he has thought about this educational society, now I think that his dreams would have been coming true, particularly with regard to this law college. So thank you very much for good deliberation, good opportunity, good good things that you have given opportunity to discuss. And definitely, I think that in day to come, again we will witness so many again good good opportunity to discuss so many things. So I just congratulate this law college as well as law society, as well as with the their very good authority, who are really very helping hand to cooperate with the teaching force as well as non-teaching force, as well as the student, to bring such a discussion on the floor. That the subject is very vibrant, very much contemporary, relevant, and really thought-provoking rather. So with these words, I think that this seminar is to be a very great success, but real success will definitely would have to be reflected into the mind of the people, and by bringing this discussion into your action, because without action, if you are thinking so much, it will be without plan, without things, without outcome, everything will be the fruitless. A machine is only very better if it is useful to give the result. The same way, the seminar is supposed to be very much fruitful if the thought discussion, the derivation of thoughts, that sharing of the thought would have been bring into the action by the all those budding lawyers who are entered to take education at this particular things. I also feel to be very much proud to be the alumni of this institution, and this is also my alma mater. Thank you very much.
Thank you, sir. To you, sir, for being real head of humanities, that is the Dean of Faculty of Humanities, and constant support. Thank you so much.
Thank you, sir. Thank you for your valuable observation and inspiring address, sir. We are greatly indebted to you, sir. Thank you very much, sir. I now call upon respected principal, Dr. Varsha Deshmukh ma'am, to deliver her introductory remark. Ma'am needs no introduction, but it's my privilege to introduce her to the gathering. She has done a PhD in human rights law and also worked as solicitor in United Kingdom. At present, she is working as a principal at Dr. Punjab Rao Deshmukh College of Law, Amravati. She is visiting faculty at Academic Staff College of Sant Gadge Baba, Amravati University, Amravati. She is also the coordinator of Human Rights Diploma course at YCMOU Nashik Center at Amravati. She has major research project in law sponsored by UGC New Delhi. She is also the director of Image Foundation, an NGO, and is a member of various social organizations. She is also the ex-president of Chamber of Commerce of Industries, Amravati. And her latest achievement is that the Kartavyam Prerna Puraskar at the hands of Honorable Governor Bhagat Singh Koshyari, presented by Kartavyam Social Foundation, Pune. She has also been awarded National Women's Empowerment Award by International Association of Educators for World Peace. Ma'am has also received Women's Bhaskar Award. She has received many awards and accolades, and many are waiting. So, ma'am, it's my humble request to you that you should address this gathering. Thank you, ma'am. It's over to you.
Thank you, Dr. Vadive. After having 2 days brainstorming sessions, now we are towards the last phase of this conference. Dignitaries of this valedictory session, Honorable Gajananji Punkar, who is the patron and the vice president of Sri Shivaji Education Society. Respected Dr. Vijay Kumarji Chobe, who is constant source of inspiration, who is in real sense the head and the dean of humanities, faculty of humanities of Santa Gadge Baba University, Amravati. And I think I'm really overwhelmed and very glad to be here for giving the concluding remarks, that is the presidential address. Although the excellent summary has been provided by Dr. Manish Vadive, I need not repeat everything again here. In the opening, at the inaugural session, we had dignitaries who really have boosted our spirit to move ahead with all the technical sessions. There were many plenary sessions. There were many dignitaries and the resource persons who contributed this conference in a true sense. We did not have like presentation sessions because many participants have requested to present their paper in the conference. But since we got very good response for the research nebula, which we are published, very soon we are going to distribute the link, that is the online research papers, and that is why we could not accommodate them to present the papers in the conference. Although the co-chairpersons of all the sessions have contributed or given the summary of the papers which we have gathered. It was overwhelming response, since we expected it was much more than the expectations. And that is why this conference, I think, is a great success. Even though I think that COVID was the blessing in disguise, because after opening of the college and the offline classes, and it was in midst of opening and then closing of COVID, we could invite, it was long decided program, still before in January also, I mean before January, but finally, eventually we could implement this international conference in the first week of March. And I think the COVID was blessing in true sense in the disguise. So while concluding every speakers, again, I would like to thank Elena, who has given us the comparative aspect study of commercial law, which was the first session, plenary session of this conference. She has given us UK, Irish, emeritus, and then United States status in the commercial law, and cryptocurrency specifically she focused, where the India is yet not very clear about the cryptocurrency status in India, which is recently, I think government has given passed some bills and regulation on this topic. After that, Mr. Vikram Sopti, he is specifically practicing in the commercial law, has given us insight on the vertical agreement, what is about then role of commissioner of the commercial competition law, and then he really given us the insight about how to stop the abuse of big companies, and then how the Bitcoin works, how the Microsoft company has had its monopoly over the market. I think even the Dote sir, who was the chairperson of the session, has said we are not very much aware about the commercial law, because it is very much in practice in the big cities and the metro cities, where the entrepreneurs and the real trade competitions are there, and wherein the big business tycoons like Reliance, Microsoft, how they try to overshadow the small entrepreneurs and the traders. So it was totally new area, and which really was very informative session for all of us. Dr. Dhote also suggested us to this conference should be contributed a lot, and we should give report to the government after concluding the sessions, and that will be real contribution of the conference in future. Then in today we have a women empowerment session. In women empowerment session, in spite of having a busy schedule, as the Prime Minister was visiting the Symbiosis Institution, Dr. Gurpur Madam made it a point to send us the video and to be present virtually on this conference. Dr. Gurpur Madam has given the Women Index, and she has suggested, recommended many points for the women empowerment on the eve of women empowerment, like, and she urged, and which is the need of an hour, to look at the changing international scenario, and where the gender specific projects needs to be spreaded all over the community, and then equal participation and making the choice at par with the men are the real crux of the women empowerment. And then we had Sharmila Guge Madam, who has given a particular data, and she has also stated that there is a need for the women not only empowered through laws, through economics, finances, but emotionally and psychologically she needs to empower. And it is a collective conscious responsibility of everybody, not only women, but the men, to march ahead in this empowerment schedule given by the United Nations. And we, being the member of various agreements to the international level, it is a primus responsibility of Indian citizen to abide with the international agreements and treaties. Then we had Madam Inamdar, Madam many, let me, because it was overflown. Sharmila Guge Madam, Tatiana, who really have given the comprehensive picture for the entrepreneurship and how to contribute in the company sector, that she has given very specifically. Then we had Dr. Anjali Thakre, who herself is empowered woman, who is an international player also, has given insight to our journal. The topic of most of the writers have written on the women empowerment, and that was really, I think that journal will be the will contribute very significantly in this conference. Dr. Asmita Vaidya also has given added some inputs like surrogacy, and then some other issues which are very valuable for all of us. Then I think it was Mr. Anbhule sir who has opened the session with the human rights, which is the, I think, which is very significant, crucial area, not only in India, but the worldwide at large, who spoke on the social, economic, and then he spoke about the sustainable development for the healthy and the clean environment. Portugal was the first country in 1976 who has given weightage to the healthy and a clean environment. I think the COVID was the witness that how the clean and healthy environment is necessary, which is also given in the Article 21, which says that, which is a fundamental right, where every citizen has a right for the healthy and a clean environment. After that, it was Mr. Sajid Sheikh, who is also the joint organizer of this conference, and also given us insight for the immigration law and the European Court of Law, which how they have contributed to the human rights, and which is, I think, success of this conference. After that, Mr. James Collins, who have given us, who told about the Strasbourg document. He spoke about European Convention and meticulously informed us about the European Convention sections, and which gives us unrelated right for the human rights. He spoke about the unlawful to the public authority which enacted the law in Europe, but just because the European citizens are very vigilant, one cannot surpass the human rights. And then he has also stated about the various pieces of law which actively and enforced in the United Kingdom. After that, we have Archana Gadikar madam, who literally meticulously studied the conference journals and gave us the details about how this, and also told about the first and the second and third generation rights. And she also said that access to the technology, that is to the right to digital world, I think that is still the world is lagging behind, and the implementation and using of digital world is more, I think, ahead. And then the law has to cope up with the new situations and the new things. But I think the fourth generation right, which is a duty oriented right, which is very important in this journey of all the discourses what we spoke here. I think the conference makes a mark to open many burning issues and challenges. Dr. Smita madam has given the studyful insight to this conference and accepted our invitation in spite of her busy schedule. I think each and everyone contributed a lot. Last but not the least, I just would like to say here that all the technical sessions like commercial law, the conference has touched various issues like emerging trends, innovations, cryptocurrencies, banking sector, intellectual property. Resource persons have really contributed a lot for this conference. Then for the women empowerment, I think, and on the eve of International Women's Day, day after tomorrow, I think that was the real celebration of Women's Day by conducting this empowerment session. To highlight these sessional issues, we have many persons, they have really contributed for the women empowerment. Then technical session on human rights also have given us new sight for the further journey in the human rights. I think this was very brainstorming sessions and all. contributed, made this conference very successful. We really look forward to see you again. I think this is not the end, but the beginning of new association and the new plethora of the conferences ahead. I thank from bottom of my heart each and everybody who have contributed this conference and my team who really slogged hard for success of this conference. I think at the end, the convener and the team will give the vote of thanks. So again, with the new horizons, we'll come again for giving you more to open the knowledge of world. And then I take your leave for by giving the concluding remarks. Thank you so much. Over to Ramteke, sir.
Thank you, ma'am. Thank you for your constant support, guidance, and inspiration. Thank you for your inspiring words, ma'am. Thank you very much. I would now like to call upon the convener of this international conference, Dr. Nandakishore Ramteke, sir, to deliver a vote of thanks. Over to you, sir.
Thank you. Thank you, Manish Vadia, sir. Thank you, madam, for giving me a privilege to propose vote of thanks of this international conference. I think this international conference provided the platform to the delegates, research scholars, and students to discuss the burning issues which are under the conference for sharing his knowledges and ideas. We are proud to announce that a total 51 research paper received from this journal from the academicians and research scholars for the peer-reviewed journal. This overwhelming response is unforgettable memories in the history of our college. I would like to thank all those academicians and research scholars on this occasion. Now, over to the valedictory section. First of all, I would like to express my sincere thanks to Chief Patron, Honorable Harshavardhan Ji Deshmukh, President, Sri Shivaji Education Society, Amravati. Without his motivations and support, this international conference is not possible. Sir, sending a best wishes on this occasion. Once again, I thanks to Harshavardhan Deshmukh, sir, on this occasion. Thereafter, I would express my gratitude to guest of honor of this valedictory function, Dr. Vijay Kumar Chaube, sir, Dean, Faculty of Humanities, Santa Gadge Baba, Amravati University, who sharing their views on the topic and a constant support to this international conference. Thank you, sir. Thereafter, I would like to express my sincere gratitude to our president of this valedictory function, Advocate Gajanand Ji Funkar, Vice President, Sri Shivaji Education Society, Amravati, who gives valuable time and make the event graceful. Thereafter, I would like to express our sincere thanks to the Honorable Dilip Babu Ingole, Treasurer, Sri Shivaji Education Society, who gives constant support to organize this international conference. Thereafter, I would like to express my gratitude to the international resource person. The first resource person is Elena Magensharian, International Legal Council, Legal Tech Solicitors, Columbia University, who accept the invitation of our international conference and present his paper and his knowledge with us under the technical section 1. Thereafter, I would like to express my sincere gratitude to next international resource person, Tatana Navina, co-head of international arbitration, Russia, who gives a valuable guidance on this technical session too, on this occasion. Thereafter, I would like to express my sincere thanks to the next resource person, that is the James Collin, the barristers 36 before Row Chambers, UK, who accepted our invitations and gives us a valuable guidance under the technical session 3. Thereafter, I would like to special thanks to the guest of honor of this inaugural session, Advocate Jayant Jayabave, the member of Bar Council of India, who sharing their views on the topic of international conference under the inaugural session. Thereafter, I would like to special thank to the Advocate Yashomati Thakur Madam, Cabinet Minister, Women and Child Welfare Department, Government of Maharashtra, and Guardian Minister of Amravati region, who sharing their best wishes for this international conference. Thereafter, I would like to sincere thanks to Vikram Sopti, partner of law firm New Delhi, who gives a valuable guidance under the technical session 1 for the topic under the competition law. Thereafter, I would like to special thank to all the principals of our various colleges who attend the conference by way of inviting a chairman and co-chairman. The Dr. Asmita Vaidya Madam, Principal, Government Law College, Mumbai. Dr. Shaistra Inamdar Madam, Officiating Principal, Navjivan Law College, Nashik. Dr. Deepak Dhote, Principal, Brizlal Biani Science College, Amravati. Dr. Smita Deshmukh Madam, Principal, Matoshri Vimlabai Deshmukh Mahavidyalaya, Amravati. Dr. Anjali Thakre Madam, Principal, Shri Shivaji College of Physical Education, Amravati. All these principals, by way of inviting a chairman and co-chairman, present in our session and give a valuable time on this occasion. I would like to thank all these principals on the occasion of this valedictory function. Thereafter, I would special thanks to Dr. Archana Gadekar Madam, who is Associate Professor of Sayajirao Gayakwad, Baroda University, Gujarat. She gives a valuable research paper concluding aspect and given enlightened aspect on this occasion. I would like to thank our resource person, Dr. Rajendra Anbule, ADR, Supreme Court of India, who accept our invitation and with us in this technical session 3. Thereafter, I would like to thank our next resource person under technical session 3, technical session 2, that is Dr. Shashikala Gurupur, Director, Symbiosis Law College, Pune, who sharing his views under the technical session regarding the woman empowerment. Thereafter, I would like to special thank to the Chief Editor of Research Nebula Journal, peer-reviewed journal, Professor Ganesh Khandare, who gives a constant support to publish the research paper and accepted all the research paper in the Research Nebula International Peer-Reviewed Journal. Thank you, sir. Thereafter, I would like to special thank to the co-organizer of our international conference, Mr. Sajid Sheikh, Managing Director, Senatorial Solicitor UK, for giving a constant support to organize this international conference. Thank you, sir. Thereafter, I would like to thank our principal and organizer of this international conference, Dr. Varsha Deshmukh Madam, who constantly inspiring to conduct this international conference and give a valuable support on this occasion. Thereafter, my deep sense of thank to and appreciation to the participants, delegates who are from foreign countries and our countries, and the research scholars who attend this conference last 2 days and attend the technical session. Therefore, I would like to thank all these participants on the behalf of this Dr. Panjabrao Deshmukh College of Law. Thereafter, I would like to special thanks to our organizing team members, that Dr. Manish Wadive sir, Engole sir, Dr. Dabade sir, Prachi Kadu madam, Dr. Prachi Kadu madam, Dr. Radhika Deshmukh madam, all these members constantly in support to organize this international conference. On this occasion, I would like to thank all these members. Thereafter, I would like to thank my teachers who are supporting me to organize this international conference and given instigation and given inspiration on this to organize this program, international conference. Then the last but not the least, I would like to thank our technical team, without which this international conference is not possible. And I think this technical team playing a very important role in this international conference. Therefore, I would like to thank Mr. Sahil and Preeti Vidyate madam, who are given a constant support to our technical aspect under this international conference. Thereafter, I will thanks to all those who are supporting me under the conference and outside the conference regarding this successfulness. Thanks to all. Thanks to all. Over to you, Manish Wadive sir.
Thank you very much, sir. Thank you very much. With that, we come to close of this international conference and valedictory session. Officially, we can rise now for national anthem.
भारत भाग्य विधाता, पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा, विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा, तव शुभ नामे जागे, तव शुभ आशीष मागे, गाहे तव जय गाथा, जन गण मंगलदायक जय हे भारत भाग्य विधाता, जय हे जय हे जय हे, जय 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 हे।